get it on tape and destroy my plausible deniability that I was here. I'm Dan Polsby. I'm the Dean of Law School. The Information Economy Project is one of the diadems in our crown, and we are very grateful to Brent and Tom for organizing this. This is a room full of friends and students. I intend to spend this morning and lunch actually learning something. Very seldom does that come my way anymore since I've been in academic administration and very remote actually from learning anything. But I'm making an exception this morning. It's Friday morning and what the hell. My office is to welcome you. Thank you for coming. This is going to be a terrific program as we see. If you don't have one, Brent will pass them around. I hope you enjoy your morning and your lunch. Professor Hazlett, I yield the microphone to you to present our program.
Thanks, Dean Polsby. I've always said you're an excellent dean. I didn't know that learning something. I didn't know that learning something was in your job description, but I'm happy to learn it. Thanks very much for coming. We have a very exciting program. I would like to reiterate Dean Polsby's note. Brent Skorup, who works with the Information Economy Project, has worked very assiduously to put all this together, and I thank him for his efforts. And I'm sure I'll thank him when it's all running smoothly and over this afternoon. As you can see, we're not in the law school technically. We're in Founders Hall, which is right next door to the law school, but this is a nice room for us. And we have a nice turnout today. And so this is the room we needed to move up to. Our keynote speaker this morning is a very special guest here at George Mason University. Josh Wright is a graduate of the University of California at San Diego, and then went on to UCLA where he got JD and PhD in economics, and then he joined the law faculty here at George Mason University in 2004. In the next few years, he proceeded to publish a very small amount of time, over 60 articles and book chapters, many having to do with industrial organization, antitrust, and the analysis of consumer welfare in competitive and less competitive markets. We are delighted that he has, since January 1st of 2013, been a sitting commissioner on the Federal Trade Commission and has moved on to apply his consumer welfare evaluative talents at what we'll call a higher level. So it's a real treat to have him come back. He was a great colleague here. We hope in the future he'll be a great colleague again, perhaps at some point. But it's always nice to see Josh, and always great to hear his sage commentary on the events of the day. And his keynote this morning, Broadband Policy and Consumer Welfare, the Case for an Antitrust Approach to Net Neutrality Issues. Josh Wright. You have to hold it.
He speaks loud.
Good morning. Thanks for the introduction, Tom. I'm delighted to be here today. Particularly happy to be back at George Mason, and delighted to see quite a few familiar faces. Special note for my students and former students, this is what I look like in a suit, which some of you have never seen before. And also, it's very happy to be back here. This is a truly fantastic institution, and one that played an important part, the most important part in the development of my career. So it's just it's wonderful to be back. Thank you also to the Information Economy Project and Tom and Brent for putting together this terrific conference and for the invitation to share my views with you today. Today I'm going to talk about competition regulation and broadband markets from a consumer welfare perspective. The consumer welfare perspective is the lodestar of competition policy and antitrust analysis generally, and of course guides decision making at competition enforcement agencies like my own, the Federal Trade Commission. More specifically, I hope to make the case for why antitrust analysis is particularly well suited for addressing the concerns raised and the long-standing debate surrounding net neutrality in a manner that best serves consumers, and to explain why I believe the Federal Trade Commission's core competencies as an antitrust and consumer protection agency render it equal to the task. In doing so, I plan to highlight several of the economic problems with the current regulatory scheme found in the Federal Communications Commission's net neutrality rules, and to discuss why antitrust rule of reason framework can be used to analyze business practices in the broadband sector, to separate socially beneficial practices from those that may be harmful to consumers, in order to create a regulatory scheme that delivers the highest rate of return in terms of consumer welfare. I'll also highlight some of the FTC's institutional advantages when it comes to dealing with these types of vertical restraints and contractual issues in broadband and other industries. Before I get too far along, in addition to the suit and tie and other things that's new is that in every speech I say, the views I express here today are my own and do not reflect those of the Commission or any other commissioner. With that disclaimer out of the way, let me begin briefly by setting the stage and talking about the state of play in the net neutrality debate a little bit. As many or all of you know, in December 2010, with the dissent of 2 commissioners, the FCC released its final order regulating broadband providers. That net neutrality order had 3 primary components. First, the order includes transparency provisions that seek to improve visibility into broadband provider practices by requiring network providers to explain their services to customers. Second, the order contains no blocking provision that requires broadband providers to permit customers to use whatever computers, mobile devices, or other applications they desire with the network access they purchase. And third, the order contains a no unreasonable discrimination provision that imposes some restrictions upon how broadband providers price and package their services. The first in this regulatory trio has generated only modest controversy. The second and third, however, have created a bit of a firestorm over both the FCC's legal jurisdiction and, from an economist's perspective, the issue of the ultimate economic effect of the regulation. These latter regulations are intended, in large part, to address concerns that broadband providers might adopt business strategies and practices to disadvantage rivals and ultimately to harm competition, and therefore to leave consumers worse off. Proponents of net neutrality fear, for example, that a broadband provider might enter into a contract with an online video site to deny rivals' video sites access to the provider's subscribers. Exactly how tightly the regulations contained in the order will be enforced and in what scenarios they will be applied remains unclear. But the order itself gives the FCC fairly wide latitude to challenge all manner of network management if it's deemed unreasonable, and enforcement efforts to date do little to assuage concerns that the regulation scope categorically bars various forms of conduct that economists may describe, discussed in more detail, as efficient in consumer welfare enhancing economic integration. Now, the FCC's attempt at imposing net neutrality regs is hardly unprecedented. Indeed, only 8 months prior to issuing the net neutrality order, the DC Circuit struck down the FCC's first attempt at invoking ancillary jurisdiction over internet network providers. That ruling stemmed from the FCC's issuance of a policy statement in 2005 that first outlined principles eventually adopted in the 2010 order. The FCC later sought to enforce those principles by sanctioning Comcast for managing network traffic by differentiating data speeds for certain peer-to-peer file sharing applications. Comcast appealed, to the DC Circuit, challenging the FCC's authority to regulate internet network providers. In a somewhat striking rebuke of the FCC's claim of ancillary jurisdiction, the DC Circuit held the FCC lacked any statutorily mandated authority to enforce its net neutrality rules. That, of course, was not the end of the story. Significantly, the FCC employed a substantially similar ancillary jurisdiction theory as the one rejected in Comcast to adopt the net neutrality order. The Commission's latest rulemaking, not surprisingly, has become embroiled in yet another round of litigation, this time with Verizon and Metro PCS, regarding the agency's authority to regulate the internet. The outcome of that litigation, which is currently again before the DC Circuit, may determine whether the FCC ultimately stays on as the top cop on the internet beat, or whether the responsibility may fall somewhere else. Now, I won't bore you, I'll try not to bore you, with the details of the parties' jurisdictional arguments or speculating about the likely outcome of that case. Most, if not all of you, are at least as well positioned, if not better than I, to play that game. What I will say is that I think the net neutrality order is strikingly poor policy when analyzed from a consumer welfare perspective. Not least of all because it's premised upon the not so subtle irony that the best way to preserve the internet as an open and competitive platform is by imposing a set of far-reaching regulations never before imposed upon it. But even more concerning is that the net neutrality order deploys a set of relatively blunt and rigid rules, indeed in some cases categorical bans, to deal with complex legal and technological problems in a manner that ultimately may prevent precisely the type of investment and innovation that's fueled the internet's growth to date. Of course, none of this is to say that competition in broadband markets should be immune from the kind of scrutiny given to other areas of the economy. Indeed, I agree with net neutrality proponents that it's at least theoretically possible that a broadband provider may enter into an arrangement that could potentially harm competition and consumers under certain circumstances. I also firmly believe that where there's sufficient evidence to show that such arrangements have been used anti-competitively, there should be a regulatory regime tasked with policing and prohibiting such arrangements. The critical question, however, is not whether anti-competitive arrangements should be barred. On that, I think there's a fairly broad consensus. It is instead on whether we can identify the best regulatory regime for addressing that particular concern. As I'll discuss in a moment, I think antitrust quite clearly offers a far superior approach to addressing potential anti-competitive practices in broadband markets than the current rules embodied in the net neutrality order. To understand why, I want to spend some time talking about the tensions between the FCC's net neutrality order and the economic and empirical evidence related to vertical restraints, as these contractual practices are generally referred to within the economics literature. At its heart, the net neutrality order seeks to prohibit broadband providers from entering into vertical contractual relationships out of the fear that they'll have an incentive to disadvantage rivals and ultimately harm competition. Support for this fear comes from the modern vertical foreclosure theory emerging from what economists describe as the raising rivals cost literature, which outlines the conditions under which a monopolist can disadvantage rivals, reduce competition, and ultimately harm consumers. Students of antitrust, some of mine in this room, will recognize that these economic concerns are identical to the animating antitrust rules governing vertical relationships. And indeed, while there's little dispute among industrial organization economists that vertical restraints might be used anti-competitively, that possibility represents but one side of the consumer welfare ledger. The fundamental failing of the net neutrality order from an economic perspective is that it contains a categorical prohibition against vertical contracts without acknowledging the vast economic literature and empirical evidence supporting the view that those contracts not only can be, but are usually pro-competitive. Although it's well accepted that vertical contracts occasionally can lead to anti-competitive foreclosure, it's equally clear and has been long understood that these contracts are part of the regular competitive process and can generate significant efficiencies that enhance consumer welfare. The economics literature is replete with pro-competitive explanations for these types of arrangements. For instance, these arrangements can create efficiencies by reducing double marginalization, preventing free riding on manufacturer-supplied investments, and aligning the incentives of firms along the same vertical chain of distribution. In fact, these types of arrangements, vertical contracts, are frequently observed between firms lacking any meaningful market power, implying that there must be efficiency justifications for their use. These efficiencies are at least partially passed on to consumers in the form of lower prices, increased output, higher quality, and greater innovation. In addition to the theoretical economic literature, there's considerable empirical evidence that strongly supports the view that these arrangements are more often than not pro-competitive. Over the last 25 years, there's been a concerted effort to pair a robust set of empirical evidence with the various economic models of vertical restraints. These studies undeniably paint a picture that vertical restraints are typically pro-competitive and cut sharply against the idea that vertical contracts and broadband markets likely, much less generally, are used in a way that harms competition. One survey of the existing empirical literature conducted by a group of FTC and DOJ economists observes that, quote, empirical analyses of vertical integration and control have failed to find compelling evidence that these practices have harmed competition, and numerous studies find otherwise. And while some studies find evidence consistent with pro and anti-competitive effects, quote, again, virtually no studies can claim to have identified instances where the vertical practices were likely to have harmed competition. Another survey of empirical studies by leading economists reaches a similar conclusion, finding, quote, it appears that when manufacturers choose to impose restraints, not only do they make themselves better off, but they also typically allow consumers to benefit from higher quality products and better service provision. The evidence thus supports the conclusion that in these markets, manufacturer and consumer interests are apt to be aligned. Another more recent analysis of studies post-2009 concludes that, quote, with few exceptions, the literature does not support the view that these practices are used for anti-competitive reasons, and supports a fairly strong prior belief that these practices are unlikely to be anti-competitive in most cases. Admittedly, when one looks at these studies, an overwhelming majority deal with markets unrelated to broadband, cable, or wireless markets. But there's no evidence that shows that vertical contracts in broadband markets should be treated differently, or that they are more likely to be anti-competitive than pro-competitive. Indeed, the handful of anecdotal examples of foreclosure by broadband providers over the course of nearly a decade, even when the case is viewed in the light most favorable to net neutrality components, evinces the pervasively pro-competitive nature of these arrangements. In the FCC net neutrality order itself, the FCC responded to the need to cite economic evidence demonstrating vertical foreclosure in broadband with a single study. It was not concerning broadband services, but cable video. And it should be noted that this one paper merely suggested that anti-competitive vertical integration might occur, but could not document it in the data that it itself examined. Moreover, the marketplace experience demonstrates that, quote, non-neutral business models deployed by broadband providers have often proven highly efficient. Take, for example, walled gardens, which have played an essential part of the internet's development by bolstering incentives for investors and spurring innovation. In the mid-90s, when most web content appealed to mass market consumers, AOL paid brand name companies such as Time Magazine and New York Times to launch a new business model that offered custom content exclusively to its subscribers. This fueled competition with rival ISPs and gave AOL the incentive to aggressively market its services to new customers, which ultimately resulted in the distribution of some 250 million disks with AOL software. For my former students, I'll show you what that looks like later. And thus rapidly increased consumer access to the internet. Preferential deals with internet service providers also spurred innovation among web browsers. In 2002, a fledgling Google was able to strategically achieve economies of scale by beating out its competition in a bid to become the default search engine on AOL, then the country's leading internet service provider, by offering a substantial financial guarantee. To be clear once again, the economic literature and empirical evidence does not claim that vertical contracts never generate foreclosure or harm competition. There clearly can be disagreement about the likelihood of competitive harm from a specific vertical arrangement in any given case. When the theoretical literature demonstrates, however, what it does demonstrate, however, is that vertical contracts, including those captured by the net neutrality order, are not always anti-competitive, and in most cases are pro-competitive. This is a critical observation for answering the question, what kind of regulatory regime and legal rules governing this behavior will best serve consumers? The order clearly does consumers a disservice by employing an overly rigid, one-size-fits-all categorical ban on broadband providers' ability to enter into arrangements that the literature demonstrates are more likely than not to render consumers better off. The question then, which I'll turn to next, is whether antitrust offers a superior alternative. From the title of the talk and what I've said so far, I bet you know where the smart money is on the answer. Vertical contracts pose a more complex problem for fashioning an official legal rule than many other types of business arrangements. Whereas it's relatively easy to establish rules to address conduct that is either presumptively anti-competitive, in my world of antitrust, take the cartel price-fixing arrangements, for example, or nearly always pro-competitive, above-cost price discounting. Vertical contracts have ambiguous welfare effects. Lacking any method for identifying network discrimination that should be barred as anti-competitive, or absolved because it's pro-competitive, the FCC order chose a blanket prescription that bars all or nearly all vertical arrangements by broadband providers. What approach has antitrust taken to what amounts to an analytically similar, if not identical, problem? Significantly, what has been a novel dilemma for the FCC is a problem antitrust has been grappling with for over a century, and for which, fortunately, it offers a fairly clear solution. Indeed, over the course of the last century, antitrust jurisprudence has developed a highly sophisticated rule of reason balancing approach for investigating and adjudicating, based upon the economic evidence, various types of vertical arrangements. The rule of reason requires each vertical arrangement to be assessed by marshaling the available economic literature and empirical evidence in the case at hand to determine its actual competitive effects. Indeed, antitrust law initially adopted and ultimately rejected, largely based upon the evolution of the economic literature described, a categorical prohibition not unlike the one adopted in the neutrality order. In assessing whether antitrust rule of reason framework offers a superior alternative to net neutrality regulations, it's first necessary to identify the features of a desirable rule. As I previously mentioned, I believe any rule governing competition policy, including competition in broadband market, must focus upon consumer welfare. Now, a legal rule that maximizes consumer welfare must take at least three factors into account. First, it must assess the probability the challenge business practice is going to be anti-competitive. Second, any rule is going to lead inevitably to errors. Under the net neutrality order's categorical prohibition, for example, instances of pro-competitive conduct will be erroneously condemned for consumer welfare. Under the rule of reason, two types of errors are possible. False positives in which pro-competitive conduct is wrongly condemned, and false negatives where antitrust fails to condemn conduct that's actually anti-competitive. A sensible framework from a consumer welfare perspective evaluates the magnitude of both these types of errors and takes them into account in designing its rules. Third, a framework must acknowledge the administrative costs of implementing alternative legal rules. Clearly, in this case, a bright line prohibition is less costly to administer than a case-by-case analysis involving a rule of reason. The framework I've described above for assessing legal rules is often in the antitrust literature described as the error costing approach. Importantly, it allows for the use of new evidence to update our beliefs as new economic learning is generated. A rule that focuses upon minimizing the social costs of false positives, false negatives, and administrative costs is the one most likely to generate the highest rate of return. So when would a categorical prohibition like the per se rule in antitrust or a blanket restriction on vertical contracts found in the net neutrality order be sensible under such a thing? Such a blanket rule or per se prohibition would be appropriate only if vertical contracts are overwhelmingly, but not necessarily always, likely to cause competitive harm. and the ability to engage in a more fact-intensive inquiry to identify instances of pro-competitive behavior, provided only a small marginal benefit to consumers. Thus, for the net neutrality rule to generate consumer welfare gains relative to the antitrust standard, it must be the case that there's a substantial basis in the economic literature and empirical evidence upon which to conclude that this sort of contracting is nearly always anti-competitive. As I've discussed, the economic theory and empirical evidence decidedly does not support that view. Now, proponents of net neutrality often argue that the fact that antitrust analysis might not prohibit all use of vertical contracts is a bug rather than a feature. They in effect argue the rule of reason is too restrictive, because it only goes after instances of foreclosure or discrimination in which consumer harm can be demonstrated. My response to that is, well, yes, that's precisely what the rule of reason does. Its role is to separate the wheat from the chaff and identify pro-competitive from anti-competitive. While the affirmative case for antitrust over net neutrality on consumer welfare grounds is fairly clear, the fact that antitrust might not work in all cases does not default to the position that categorical ban is the superior approach. The critical question is not which approach captures all of the potentially anti-competitive opportunities, but which one best enhances consumer welfare. I'm quite confident that if the antitrust regime, after 121 years of trying and developing an institutional capacity and expertise in its application, has trouble applying the rule of reason in the context of vertical contracts by broadband providers, it's difficult to imagine another approach doing much better. Having made the case for why I think antitrust offers a superior approach, I'd like to spend the last few minutes discussing a few of the FTC's institutional advantages that render it uniquely capable, in my view, of both tackling these complex questions related to competition and broadband companies, and nimbly sidestepping the often perilous political debate surrounding network neutrality. First, as my colleague Commissioner Wallsten, another George Mason professor, has pointed out, the FTC's core competencies as an antitrust enforcement and consumer protection agency, combined with the expertise it's developed in matters related to the internet and broadband access, position the agency well to deal with the difficult legal, economic, technological issues related to network neutrality. For example, in 2007, Commissioner Wallsten, then director of the FTC's Office of Policy Planning, led a task force investigating issues related to internet connectivity and network neutrality. The task force brought together consumer advocates and experts from business, government, academia, and the technology sector to explore competition and consumer protection issues related to broadband and internet access. The investigation culminated in the issuance of a comprehensive staff report that represents the agency's vast learning on broadband access and net neutrality issues. The FTC has also had considerable experience in other areas that touch upon network neutrality. For instance, the FTC has analyzed a number of virtual arrangements similar to those following under the network neutrality umbrella. Several cases recently brought by the FTC suggest the agency is perfectly capable of bringing cases based upon vertical theories. In addition, as former Chairman John Leibowitz has observed, the focus upon increased visibility in broadband provider practices makes network neutrality very much a consumer protection issue that may also be addressed by relying on the FTC's vast experience with transparency and disclosure. Lastly, by placing consumer protection and antitrust enforcement aspects of net neutrality under one roof at the FTC, one can eliminate inefficient overlapping jurisdictions. Second, the FTC's rigorous and well-established consumer welfare analysis constrains the ability of politics, not to zero, but constrains the ability to encroach on the agency's competition and consumer protection missions. This is a particularly important feature for tackling an issue as thorny and as politically charged as net neutrality. Indeed, the FTC's recent track record supports the view that it can be trusted to assess the merits of the case based on the weight of the evidence and not the weight of the political question. Indeed, earlier this year, just before I joined the Commission, the FTC closed its investigation of Google for employing allegedly anti-competitive search practices. This was, by no means, the easy decision from a political perspective. There was enormous public pressure demanding the FTC issue an enforcement action. But in stark contrast to the way the FCC has handled the bitter debate over net neutrality. The FTC, at the end of the day, put politics aside and evaluated evidence and determining the case was not warranted under the fact. While the FTC's role in regulating broadband markets remains unclear at the moment, suffice it to say, I believe we're up to the task of addressing competition and consumer protection issues arising in internet markets generally, and more specifically, applying our considerable experience and expertise in analyzing the vertical issue associated with net neutrality. Thank you once again, Professor Haywood, for having me for the Information Economy Project, and thank you for your time.
Quickly, we'll try to get in 2 questions. Please identify yourself and jump right to your question. Please make a question.
Matt Warner, attorney at the FCC. I feel like your whole speech focused on one subset of the order, which is the paper priority aspect, and I believe it's paragraph 76. You talk about the FTCs, whether you were trying to encompass all of the open internet issues, such as peer-to-peer blocking that came about with the order from Comcast, and maybe First Amendment issues that may be related to open internet, that may be encompassed in the internet order, but maybe not for the paper priority aspect.
I think I can find an answer here somewhere in the middle. I don't think that the focus is solely on the discrimination aspects. So some, but not all, of other aspects of the order implement conduct that could and is to a normal basis analyzing the internet framework. So blocking, for example, but I leave open. I certainly agree with the proposition that there are aspects of the order that don't fall into that framework. I don't mean to say one is a wholesale substitute for the other. It's the spirit of it.
Yeah, I was wanting to know if you were running like all the open internet issues under an antitrust framework, or whether you just feel for that one aspect of the case.
I think I answered.
Yeah.
More than one and not all.
So, I'm sorry, for the antitrust framework, you would apply it to beyond just the paper priority?
Yes.
To what? The peer-to-peer blocking from Comcast?
Right, so for blocking conduct, for a number of arrangements.
Well, so I guess
that's a network management issue, so that's what you're asking.
Well, so it was at the core of the open internet in the prior Comcast order, right?
They call that network management.
Well, we also said you could sort of block websites.
Yeah, you said it was unreasonable network management.
Well, it'd be under the no blocking rule, but I wonder how it would be an antitrust law.
So, Section 2 of the Sherman Act can reach all sorts of conduct, including that is non-contractual, and analyzing it in the same framework of assessing harm and competition. So, my answer to you is beyond the context of vertical arrangements that are contractual. The antitrust framework might apply. I have no interest in getting into this. Okay. But beyond contractual pay for priority, my answer is yes. Am I willing to say to all issues under the sun? No.
Would you feel that issue works well under the antitrust framework?
Is that issue
right? The Comcast blocking peer-to-peer.
Without specific examples, as a general matter, I would be comfortable with the antitrust framework extending to that sort of matter.
Thanks very much. That was a very good question. We have to move on. One more question, please. Dr. Crandall.
I'm Robert Crandall from Brookings Institution. You, at the end, I found your kind of intriguing that somehow the Federal Trade Commission able to handle politics of dismissing the movement complaint, but perhaps the FCC is not able to handle politics of drafting the commission order. What's different in the politics? Is it statute? Is it part of the bigger statute that under which the FCC operates, and in fact you can operate under this law on trust?
I think the difference is the proof is in the pudding with respect to the common law evolution of the antitrust law over the last century. That employing a consumer welfare framework cabins discretion of decision makers, local agencies, and in courts, more so than broader framework. And you can hang that on the statute if you like. And you can hang that on public interest versus consumer welfare if you like. I think that that's a perfectly fine legal hook for it. But I think that the real mechanism is that doing case-by-case economic analysis and which ones that show that the arrangement at hand has decreased consumer welfare. It's the economics that I think cabin sort of reduces that pressure. Again, certainly not to zero. I've seen plenty of cases and written about plenty of cases in which I think the FTC has followed that sort of pressure. It's a question compared to what. I think that the economic analysis of the framework that the FTC has at least provides some protection.
Thank you very much, Josh. Great to see you again. You look good with a haircut, by the way. And, you know, it's a great honor to be an FTC commissioner, but you're going to have to wear that suit in August, aren't you? We'll take a picture of the faculty and walk around in sandals and shorts. So now it's my honor to introduce the moderator for the next panel, who I think it's safe to call him a legend in regulatory economics. After serving for 400 years at the 300, I'm exaggerating, more than 300 years at the U.S. Department of Justice, I think it was 27 years, 29 years at the U.S. DOJ Department, the Antitrust Division, and heading the economic analysis group intelligently and really with universal respect in the regulatory community here. He moved over to the Federal Trade Commission, Bureau of Economics, and he is a policymaker now at the FTC. And the FTC, I'm sure, is very glad to have him. Kenneth Heyer.
Well, thanks, Tom. I'm trying to, I wasn't sure how we were supposed to distribute ourselves. Is this for the other panelists that we're sitting with, or should we get the mic? They got a mic.
Mic right there. All right, that was the plan.
Yeah, constrained space up here, so I think in order the panelists will come up and speak, and then at the end, sit and have a Q&A.
All right, so I thought that what we would do would be number one for me to speak least, since I know least about the subject and we want to leave as much time as possible for the panelists. So we'll have each of them give their talks, and I appreciate holding questions until the end. Write down questions clearly, folks, so you don't forget them when we get to Q&A. Let me first introduce, we decided that Noam would go first. I've asked him to speak quickly because the opportunity cost of his time is particularly high. Just judging from his bio that I've been given, I think that during the time we'll be having this panel, he could have written 2 more books. Ellie is a distinguished professor of economics and finance at the Columbia Business School. You have his bio. I'm not going to read the whole thing. I think his work and his reputation is stellar and goes without necessarily having to repeat, and I'm looking forward to hearing his remarks.
This is where I should stop. So, does this work here?
I can hold it.
All right, while this is taking place, let me first thank Tom and the Dean for your hospitality and for organizing this. This is a great event. It's important. What I will do here is to engage in something that law schools perhaps consider subversive, which is I will engage in data analysis. I will provide numbers. And I say this as a 3rd-generation lawyer and married to a law professor. So that's where I met her in law school. So nevertheless, the issue of numbers in this politicized environment of Washington is a real problem. There's nothing wrong with rejecting policy based on figures and facts and numbers. Principles are important. I have no problems with that. The problem is when data comes out unfavorably to one's favorite cause, whether pro-competitive or pro-public interest regulation. At that point, many people, particularly here, will either practice cognitive dissonance and ignore the evidence, or they will slay the bearer of the unwelcome news. Washington is, in these things is probably, to paraphrase Thomas Hobbes, nasty, brutish, and long. Or they will come up with their own commissioned studies that will presumably come up with the results that are welcomed. If you torture the data long enough, it will confess to anything. So let me be clear on my position. I don't care. I don't care what the results are. I have no dog in this particular fight. But of course, it is a big fight. All issues involving media or internet are, particularly internet, where the communications among the insiders is so strong, and the coherence is sometimes also strong, and a certain amount of free-floating paranoia is also around. There, it is kind of easy to come into problems of true belief. So what I will present today here is basically three things. And one of them is based on an earlier book of mine on media ownership and concentration in America, as updated on the shuttle. Here it is. The first issue I will kind of address is the actual broadband concentration in the United States. The second one is the U.S. broadband concentration in international comparison, in context. And the third issue will be why this is perhaps not such an important issue for the future. It's important, but there is an even more important issue, and I will discuss that. Okay, now, so let's start with the U.S. Broadband concentration. So here are, and kind of go back for a second. The problem with broadband concentration, I've done this time series for 20 or so years for the US, even when there was no broadband yet. The problem is methodologically how to deal with mobile smartphone type internet access, which of course has kind of exploded in the last several years. How do you consider it? How do you count it? Now there are several ways to do it. One of them is to say it's really kind of broadband light, and we should not count it. And actually, I have, in a different context, argued against the National Broadband Plan's emphasis of wireless as broadband, saying that it will always be behind by several orders of magnitude. As much as it improves, the other stuff, the wired stuff, improves even more, and therefore we should not really consider it to be equivalent. However, the official position of the US government, the FCC, and of the National Broadband Plan is that, yes, it is broadband, and therefore, if they believe it, then I will kind of stick with the government definitions here in my analyses, all right? So therefore, kind of mobile is included, but this is kind of methodologically not so easy. I'll tell you just in a moment so you understand what is happening. First, you have to identify how many people actually have cell phones, smartphones, and that's about half of the population at this point. Secondly, of those half, about 28%, according to numbers that I have come up with, found 28% use mobile as their primary internet connection. So that's 28%, or half of it, that's 14%. Now, some of those, however, are also using both ways, and I assume, kind of just for simplicity's sake, based on some other information, that it's about a quarter, so I'm kind of subtracting a quarter but I also have to include of the people who have smartphones don't use it as a primary source, but using it as a secondary, that they're also using it to some extent. So if I consider that that's also a quarter symmetrically in the other direction, and I do all this massaging, I come to the following numbers, that in the United States, when it comes to wireless, AT&T has about 14%, Verizon has about 8.2%, and the other phone companies. And here you see also the mobile, but for the two major mobile companies, AT&T and Verizon, same companies as the wireline companies, and we're not kind of doing this by platform, we're doing this by company. And so if you add those numbers into the wireline and net out the people who have both, then you come to a number for AT&T of about 20%, for Verizon about 15%, and you see the other numbers.
What year?
This would be 2012. Okay, thank you. I should know this. Now, so if you draw these numbers, this is what you get. Now, when I said kind of a bit on the shuttle, is because in the middle of the night, I kind of thought there was something wrong with my numbers, and I remembered then that smartphones is only half of the mobile phone users, and I kind of did not kind of multiply by 0.5, and so that's what I did. And so ignore the top line and just kind of look at the lower line, and what you will see is that national concentrations are using the HHI approximately below 900, below 1,000. It is in the unconcentrated territory. And it's a sharp decline from 2-3 years ago, a sharp decline, and it is largely based on the entry of smartphones into the usage market. And that actually is going to increase more and presumably will reduce, well, okay, now, this is from a national perspective, an FTC perspective perhaps, but if you also look at it from a perspective of the actual user, the question is, what are my choices? And in the past, we had essentially two choices, cable or the local phone company, and of course, you could also put your satellite dish up there, so this is what I call a 2.5 type arrangement. Now, we have now added actually the mobile options. And so people have more options. I look at my own household, that's me and my wife. And we're a mixed marriage. She's Android, I'm iOS. And so what we have is basically connection to AT&T, me, mobile. Verizon, her connectivity. Columbia in my apartment is a third option, and a fourth option in Connecticut, where we have a house. We have a charter, so that basically we have 4 broadband providers, if you think about it, just one household. Now, so if you look at it on a local level, you have the wireless companies, the cable companies holding about 3%. The wireline companies, as you can see the numbers, the satellite companies are anemic. The mobile companies have come up to, based on these calculations, to about 18.6% as broken down and netted out. And if you look at those numbers here, this is the, again, this is now the national number, the national concentration that I showed you before, and this is the local concentration. Ignore this, please. This is the local concentration that exists, and that has also declined. And it's not low, it's about 3,000, but it's because after all, the the local phone company in its wireline and wireless manifestations has a large market share, and the cable company has a large market share. So this is not an unconcentrated market, but it is downward declining. And here's a third observation, which is this year or last year was the first time that the phone industry has moved ahead of the cable industry in broadband connectivity, if you include mobile, because cable has no mobile. And so if you include that, you see that the market shares, this is your cable, are now below those of phone. Have crossed over. And in fact, I don't see anything that would reverse that trend. So if I'd be Comcast or some other cable company, I would start kind of trying to shop around for a mobile company, such as Sprint or something like that, because the absence of the mobile connection is really going to come to bite. So now, let me move on to, so these are kind of my first three observations. Concentration declining in most recent years, and cable also declining in its national market share. Now, Now let me do an international comparison. And that is to put things in context, because people kind of tend to look at their own, and then there's something goes wrong, and they say, oh, it's the FCC, it's the FTC, it's wrong public policy, it's Congress or whatever. So if you kind of look at it a bit international, see at the trends, unless you think that all regulators in all countries are equally incompetent, corrupt, or whatever they are, unless you think that, then an international comparison kind of helps, okay, because it kind of shows you what broad trends are. It's very difficult by regulation to deal with broad trends as opposed to national aberrations. The national aberrations, say, is Mexico, for example. Mexico, where the concentrations of broadband and of several other industries are really off the charts. And so there's Carlos, the not so slim, and other kind of situations that it just has now finally got the Mexican government to look into this matter. So we have done, basically under my leadership at Columbia, an international project that includes 30 countries that account for about 80% of the world's population, 80% of the worldwide GDP. And so we compared about 13 or 14 different industries, newspapers, magazines, and so on. So let me kind of just give you the internet broadband comparison, ISP concentration. So here what you will see is that the US is, I know it's difficult to see from a distance, this is here where the US is. And these are numbers, these are 2009 numbers for international comparison. So
these are national numbers.
Pardon?
These are national numbers.
These are national numbers, yes. These are national, but I will kind of just briefly discuss the international comparison to Japan. So this is pre-mobile phone entry into this. We could not do it much newer because in many other countries the data is simply so far behind that we should be lucky to have it done. So what we find here is that the US is actually quite low in national numbers. That most countries are somewhere in the 2,000 to 3,000 type range, not low. The US is here, but there's about 1,500, and remember, with mobile phones, it actually comes down to below 1,000, as I showed you. And so the US is kind of here at the low end, and so there's Canada, even lower, Japan, even. This, by the way, was always done by national teams under a common methodology. So we basically specified how to do it, what to do, what to look for, and how to count these things. And so they did that. So Japan is lower, and of course everybody says, for example, Japan, right? You've heard that. Well, it's not so easy because first of all, Japan is only minimally lower than the US. Good for them. So secondly, Japan is perhaps unconcentrated when it comes to the ISPs. But the ISPs ride on infrastructure. The infrastructure, in my mind, is actually more important. That's why we have these kind of fights over net neutrality and so on. So the platforms are really critical. And in terms of the platforms, just to give you a basic intuition, Japan, one company, NTT, together with Docomo, its subsidiary essentially has of the infrastructure by 85%. Okay, so that's kind of just enormous market. Now, this does not include, I shouldn't have mentioned Docomo, because these numbers are only wireline. So 85%, there's cable is anemic. It has about 10% of broadband in Japan, of which one company, JCOM, accounts about for 6%, and that company was just acquired a few months ago by SoftBank, who also bought the Sprint in the United States, T-Mobile in the United States. Now, what is it about?
I was trying to be bidding for Sprint.
Sprint. Okay, so I'm sorry. Then my earlier comments were not about Sprint, but about T-Mobile again, for cable, Comcast. So this is Japan. How much more time do I have? Sorry.
You have about 6 minutes.
All right. So Japan really, even if you just look at the upper level type and in a way compare platforms with non-platforms, the assets in Japan, you will see that Japan is not really all that less concentrated. Now, if you do this on a local basis, since almost all of the Japanese ISPs are national rather than local or regional, then you come to that in Japan has a local concentration of about 1,300, and the United States had at the same time pretty much, well, actually, sorry, that number I don't have, but there's not a market difference. As far as my numbers can tell. So, Bob Crandall is shaking his head, so I wanted to kind of shake.
Local concentration is 1,200.
Pardon?
I would suggest 8 equal-sized competitors.
Is what?
I said I don't think it's
Higher.
Yeah, it's
In
much
Japan.
higher.
Much higher in Japan.
Okay, so I didn't do the numbers. I mean, the authors weren't asked to do local concentration, but I can kind of somehow take their numbers and work them out on my next slide here. Okay, so now let me kind of compare this also because there's so much data there. We'll simplify this by regions, so we kind of don't have 29 European countries around. So if you look at it by regions, you will see that North America is actually low. I mean, it's not low, but it's certainly lower in comparison to the EU countries, Asia Pacific, and to the BRICS. So I would say, from the numbers, it's not obvious that in international comparison, the United States is an outlier, has a problem, or whatever else people can fear. There might be problems, and there might be problems to deal with, and there might be problems of access, and all kinds of other things. That's possible. But the problem is not one of the U.S. when it comes to concentration somehow being more concentrated, and therefore the problem exists. So sometimes people kind of don't like stories that are not kind of like doom and gloom. And so almost, particularly in academia, it's kind of like, what's wrong with him? Doesn't he know that? Okay. But this is what the numbers show. If you have better numbers, go ahead. So now comes my third point, and that is why we should look into the future rather than into broadband, which in some ways is the present. And I think that I'd like to identify issues that are emerging, and those issues are the issues of what can be called the media clouds as the primary users of internet. And this is all very exciting. We're talking here about companies such as Netflix that now have, by this calculation, a evening primetime evening share of internet traffic of about 33%. 33%, YouTube of 13%, and a couple of others, iTunes and so on, which is really good, really nice. I can find myself watching mostly television, whatever it was used to be called television this way. But that's just the beginning. That's kind of like over-the-top OTT type stuff. But I think kind of the marriage of that with more kind of storage and with clouds, and clouds that start out as providers, that start out as storage, and then kind of do software as processing as services. Once you kind of factor this in, it's going to make a real kind of big change. Here are some of the current cloud providers, but I think that's just the beginning. Because clouds, in my view, I mean, this kind of super clouds, are going to be really important and even dominant in the media environment. Why? Because for some of these reasons, let me kind of explain. The problem of the future will be that this kind of television of the future and other media of the future is going to be very diverse in terms of hardware, in terms of software, in terms of content, and it's also going to be global. And in that environment, there have to be intermediaries who will kind of put these things together because you cannot expect, whether it's on the standards issues or the legal and regulatory issues, to have each of these little module providers kind of do their own thing, conform to standards that even standards themselves are almost impossible to agree on in that environment. And so instead there will be commercial intermediaries who will put these things together. They will interoperate, coordinate, edit, market, finance, and so on. They will kind of be essentially the central nodes in a diversified system in which surrounded by lots of little satellite specialists. And when you do that, what will happen is, and I can kind of tell you about this some more, but my time is running out, or has run out, is that this is great and it will make for great things, but at the same time, it will also lead to a higher, more concentrated media environment. Not because of some power-crazed individual, but rather because of the fundamental economics of fixed costs and marginal costs are so high. And you can see here by this comparison already that traditional media, 20th century media, and internet media, if you look at them in comparison, you will see that every region in the world, the new media are actually more concentrated than the old media. Okay, books and newspapers are less concentrated than internet-type activities. I mean, people can talk about the long tail all day long, but the numbers show that basically you have this. For internet activities, whether it's Google or YouTube or eBay or whatever, Amazon, that there are companies with extraordinarily high market share and active around the world. And the economic logic is there. This is not kind of some kind of conspiracy or anything. So what we're likely to, and here you can see that also for the US, people are kind of saying, you know, online news media, hey, this is great, everybody can now read everything. That's true in theory, but the reality is that if you compare the concentration of newspapers in the US with online news, you will see that this is the market concentration international for newspapers. This is it for online. For online, and the market concentration has actually gone up considerably. What we've done is we have traded we are trading a system of parallel local monopolies of newspapers for essentially an national oligopoly system of online news media.
Yes, I moved on from the 2009 local. What year?
This probably would be 2010.
And the previous one had the media concentration on the world last year.
No.
Let me propose that we hold questions until later.
Okay.
I will publicly inform the speaker this time.
Okay, so I mean, the question is, do you prefer local monopolies but Wallsten, or do you prefer a national oligopoly and many fewer companies? If you're, I mean, as a reader, you actually have more choices. As a journalist, you have much fewer. So I think that kind of what we should expect here is that the content sector's concentration is going to become much more like the IT sector because it becomes more technological. And therefore, its market structure is going to resemble much more that of telecom and IT. Now, the system that kind of I showed you has a few problems. Privacy issues, security data, spreading it out, all the usual good old friends and so on, but particularly with market power, because it is clear if you just look at Google, if you just look at Amazon or Netflix and so on, that some companies will be very strong participants. Apple and iTunes and so on, next generations. And so the question then is, how do you connect between those, interoperate between the clouds? Because ultimately, that is the issue of competition. Traditionally, it has to be. And one possibility is just to do absolutely nothing and let the users in their own arrangement find their own arrangement. So that's fine. Except it's burdensome on users, it's probably going to work well. More likely is a system, again, market-based of peers, but that can lead also to exclusion of some clouds by others. And the third possibility is to create a system by market forces or by regulation of some kind of inter-cloud, a cloud of clouds where the connection points are. But still, if it's unregulated, it will leave some people out, some clouds out, and could lead to some kind of cloud lock-in and stickiness. So I thought about what are the regulatory options here, and I concluded that they're really undesirable. The only thing that you need, however, is two principles which are, when I'm trying to discuss them, are one what I call reciprocity, which is if you connect to me, I'm going to connect to you. If your customers are connected to me, my customers can connect to you. And the second principle is unbundling as an option so that you can take 3, 4, 5 services of a cloud provider that you don't have to take the whole package, so you can also choose from a third party. With those two principles, basically you don't have to do any regulation, which would be highly desirable in this field. So to conclude, I think I kind of find that the broadband concentration, partly fueled by the entry of smartphones, is declining, and therefore, by the time it's taken a while with truly capitalistic competition, it's going to shake out into some kind of handful of companies that basically a loose oligopoly. On the other hand, so that problem is declining. On the other hand, I think for the upper level system, which are characterized by clouds and media clouds, there the concentration issue is likely to emerge quite rapidly. It's more complicated because all engagements are much more complicated even than the infrastructure issues, and therefore we should be ready and able to think along and think ahead in those things as they happen. And so I thank you very much for your attention.
Thank you very much, Kelly, and I know some of you may have questions, and as I said, we'll hold them until the end. Let me introduce Marius, who I don't actually need any notes to talk about, since I know him very well. We went to graduate school together at UCLA. He was a year younger than me and a year ahead of me, which is about right. And then I ran into him again working at the Justice Department. He was there at the Antitrust Division when I got there. He ended up going on to bigger and better things. I made a little more of a lateral move. Marius is an outstanding economist, very clear presenter. He's going to be talking about something that quite interesting to me, because when he was at the FCC, they were analyzing the matter. The Antitrust Division, when I was there, was also analyzing the matter. So we actually got to work together a little bit on it. I think you'll find it very interesting, and I look forward to Marius' remarks.
Okay, well, thanks for inviting me. It's a pleasure to be here. I have a very short commute from Georgetown University across the river. Anyway, this was a transaction that was reviewed last year, not a transaction, both a transaction on the spectrum side and commercial agreements, with my focus. It was reviewed by the Department of Justice and the FCC last year and approved with conditions. And it fits in this conference because as originally structured, the merger agreements had both agencies felt significant potential to reduce broadband competition in a number of ways. I should say I served as chief economist at the FCC during the transaction, but everything I'm going to say today is based on public information. I had to check that by going to the DOJ's competitive impact statements and remedies of what the FCC said. It was pretty hard to figure out how much I saw from the agreements themselves, which were voluminous. Let's just put that aside and let's back out what the DOJ said. So that's all public information. And the views are my own, although I'd like to think they bore some resemblance to the agencies. This was an unusually interesting transaction. It was like a crash course in the evolving communications space, which is undergoing changes both in business models and in technology. On the business model side, one key issue is that people generally expect that bundles of fixed and mobile services, like Waterplace, for example, will get more traction. Both synthetic bundles and new service. Synthetic bundles meaning just buying the multiple services from one provider. And new services that combine capabilities of fixed networks with mobility, like stuff. You watch a video at home and then you seamlessly continue on the road with your mobile device while driving in the car. Great social engagement. So that's one thing. In important markets, technology and business models in flux. And I'll talk about, the deal was also quite complicated. Very complex contractual provisions. It was not a merger. A lot of the opponents said, look, this is just a merger, think of it that way, it combines Verizon and wireless with the cable companies, yada yada. Let's not. Well, you have to go through the incentive, the details of the agreements and figure out the incentives from that. By the way, the slide, the subtitle I started with, The End of the World as We Know It. That was from Craig Moffett, who was one of the top telecom analysts, who immediately when he heard about the deal, said, oh my God, this is a true speed in Verizon, and the cable companies are going to carve out things, the end of the world as we know it. But, so it's a deal that actually had attracted some attention, although it seems to have flown under the radar screen. Now, of course, we said similar things about AOL Time Warner, for those that are old enough to remember. So, take that with a big grain of salt. Okay, well, what were the three parts of the deal? The first was a spectrum sale from Spectrum Co., which is a consortium of cable companies, Comcast, Time Warner, Bright House Networks. Cox also was involved separately in the spectrum sale. This is spectrum that the cable companies bought originally with the idea that they would launch their own wireless networks, and then decided that didn't make any sense. So I'm not going to talk about that, about the spectrum sale. The 2 and 3 are collectively known as the commercial agreements. 2 is there were marketing agreements, which involved Verizon Wireless, not Verizon Telecom, although we'll talk about that in a minute, and the local cable company agreeing to resell each other's services. So Verizon could sell cable services, Verizon Wireless could sell cable services, the cable companies could sell Verizon Wireless mobile service. And moreover, there was exclusivity. They would sell only that part of services. So the cable company could sell Verizon Wireless, but could not resell Sprint or T-Mobile. And the part 3 is JOE, the joint operating entity, which is a technology joint venture, to integrate wireline and wireless services. And one of the features there was that any member of JOE would get access to the intellectual property developed by JOE, but other folks, not necessarily. In fact, there was reason to think that, let me just stop with the disclosing information.
No, keep going.
Okay, I'm going to focus on 2 and 3 and why they might, why they had the potential to reduce broadband competition. First, talk about cable services, reducing competition to the cable companies in the various services they provide, and then the mobile wireless, which is becoming increasingly important. Okay. Cable services. The cable agent agreement, as it was originally drafted, between Verizon Wireless and the local cable company in various areas, is for 5 years and with automatic renewal. And what it specifies, the key provisions were, one, Verizon Wireless may sell, let's say for a commission, the cable services, voice, video, broadband, bundled with Verizon Wireless's own wireless service. And that's even in areas where Verizon, the parent company, offered Fios, which is the direct competitor to cable. The second thing was that Verizon Wireless, if it's going to sell Fios or cable services, it has to do them on equivalent basis. We'll talk about that. And then the third was that Verizon Wireless may not market Fios outside existing Fios areas. So if Verizon Telecom were to expand Fios to a new area, Verizon Wireless, its retail stores, could not market Fios in those areas. Nor could Verizon Wireless anywhere sell DSL or other services that compete with cable, such as DBS. Now the truth is Verizon Wireless doesn't do much of that today anyway, but who knows, they might in the future. What was that? And that's my phone. Oh my God, this is embarrassing.
Saying you're revealing
Yeah,
confidential.
the way to get this. I saw Joe Klein wants to get rid of this very nicely by saying, yes, Mr. President. Okay, back to the ranch. And then finally, there were potential limits on the ability of Verizon Telecom, the parent company, to bundle Verizon Wireless services with cable competing services, such as Verizon Telecom bundling Verizon Wireless with DBS and selling a package. Now, just keeping straight who this was, Verizon Wireless or Verizon Telecom, who was doing what was itself a huge challenge. And in fact, the Verizon lawyers sometimes were getting confused and ourselves, I felt much better. But those are the main provisions. Now, why might these be problematic? Well, wireline wireless bundles are expected to grow in importance. In fact, that was the stated rationale for the deal. This is happening. And the cable agent agreement, as framed, could reduce competition to the cable companies in a number of ways. So the first was that they would impede Verizon Wireless as a sales channel for Fios. Pretty clear. One was obvious that Verizon Wireless was barred from marketing Fios in areas where Fios may be offered in the future, but is not today. Second was the equivalent basis restriction. Now let's talk about a second about that. It may have been innocuous. You can think of a situation where the cable companies and Verizon say, look, if you're going to be selling both Verizon Wireless, treat them equivalently. Don't favor one over the other. Fine. Sounds good on paper.
The equivalent basis didn't mean you got to charge same prices.
No, not the prices.
Right, I know that.
Yes, but the concern is as follows. Imagine that Verizon Telecom advertises Fios, blazing speed much faster than cable, which they do. You see these kinds of ads. Customer walks into the store, the Verizon Wireless store. There are lots of Verizon Wireless stores, a lot more than there are Verizon Telecom stores. Sees two displays, cable services and Fios, and asks the salesman, hey, which is faster? Is Fios faster than cable? The salesman says, I don't know, I can't tell you, I can't comment. But wait a minute, all your ads say that it's much faster. Yeah, but that's Verizon Telecom, I'm Verizon Wireless. You could see how this could cause some confusion at a minimum. And in fact, there was some discussion in the documents that this could be a problem. So that's the equivalent basis restriction. That it really could undermine the effectiveness of television advertising by Verizon Telecom touting Fios when the customer walks on Verizon Wireless store and the guy says no comment. Okay. The second point is that Verizon Telecom owns 51% of Verizon Wireless, the rest being owned by Vodafone. So any extra profit to Verizon Wireless accrues to part of it accrues to Verizon Telecom. And there's going to be an incentive because Verizon Wireless will be selling cable services. That creates an incentive, maybe not huge, but that's created an incentive for Verizon Telecom to scale back any offerings of its own offerings that compete with cable services. So the most obvious example is Fios, right? You can scale Fios back by either not investing in new markets or raising the price in existing areas. What happens? Some of those customers that would have bought Fios now switch over to cable services. And some of those customers in turn buy their cable services from Verizon Wireless in the bundle with Verizon Wireless. So that chain of diversion is going to create some profit to Verizon Telecom, some additional profit from raising the price of Fios or not expanding it as aggressively. Profit that doesn't exist today, because today Verizon Telecom has no way to profit from cable services. Okay. And then the last point was the possible limits of Verizon Telecom bundling. So the remedy that was adopted to deal with all these things by the Department of Justice, and by the way, we did work very closely with the Department of Justice, with the FCC at the time, and adopted essentially the same analysis, was that Verizon Wireless was barred, number one, was prevented from marketing cable services in the Fios footprint, which was defined as both areas where Fios is currently offered and areas where authority has been received to offer. So the idea is it's not there yet, but they may build it out fairly soon. In addition, after 5 years, Verizon Wireless may not market cable services anywhere unless the DOJ says that they can go ahead. So the default is that this stops everywhere unless the DOJ says go ahead. And the rationale for that was that although there's a lot of evidence that today Verizon Telecom is not expected to expand its Fios footprint, it may down the road. Things change, conditions change, and if it does expand down the road or conditions change that would make it attractive for Verizon Telecom to expand Fios down the road, you don't want to create a disincentive to that by allowing them to sell cable services. So that was the fix. And then on 3, again, there were some clarifications put that make it clear that Verizon Telecom can bundle Verizon Wireless with DBS or anything else as it sees fit. Okay, let's switch to mobile wireless. By the way, I only have 2 more, this and 2 more slides, so I think let's grab some more.
As long as there are no more calls.
What?
There are no more calls.
Switched it up, I hope. Okay, mobile wireless service. So this is the Verizon Wireless Agent Agreement, VAA, that this time appoints the cable company as an agent to sell Verizon Wireless service. Again, 5 years automatic renewal. Provision 1, the cable company may sell for a commission Verizon Wireless mobile services. And then after 4 years, Comcast, who was essentially negotiating the agreement on behalf of all the other cable companies, may choose to switch from an agent to a reseller or MVNO, mobile virtual network operator. And if it does so, other cable companies have the right to switch as well. Now, as a MVNO, you can market the service under your own brand. It's not going to be a plus rather than a minus. But there are other things. You have more flexibility in the range of products you can offer. Typically, MVNOs get access to a low wholesale price for capacity, which in turn enables them to offer a lower retail price than they can do as just a reseller of the existing service. But the point was that for 4 years they could not become an MVNO as originally framed. They had to be a reseller. And secondly, they had to be a reseller only of Verizon Wireless. They could not, that's the exclusivity provision. They could not partner with Sprint and T-Mobile. Okay. What about Joe, the joint operating agreement? Again, unlimited term, Joe would be the exclusive vehicle through which its members would develop any kind of IEP relating to integration of wireline and wireless services. And its IP would be made available only to Verizon Wireless as well as Verizon Telecom, and the cable companies that sell Verizon services as agents. Okay. So for example, Sprint or T-Mobile don't automatically get access to this IP. And importantly, in order to purchase any Joe service, a customer has to subscribe both to Verizon Wireless, be a customer of Verizon Wireless, and a customer of the cable company, because the Joe service integrates the capabilities from both. Okay, what problems could this create? Number one, as an exclusive agent of Verizon Wireless, the cable company may be less aggressive in the wireless space than either if they were resellers, MVNOs, or as partners with smaller cable wireless carriers. So the cable company said, look, we don't offer wireless today, so what's the problem? Well, that's not necessarily the but-for world, right? As I think Ellie alluded, they're going to have to think about offering wireless, right? The fact that they're not going to build their own network, and I think most people agree that that didn't pan out, that doesn't end the story, right? They could partner with, say, Sprint. They could partner with T-Mobile. Or they could insist to Verizon Wireless that they become an MVNO as opposed to just an agent. Okay, so there are other options. And those options potentially could make the cable companies more aggressive in the wireless space than if they're exclusively an agent of Verizon Wireless. The second thing was that the cable companies may foreclose Verizon Wireless's wireless competitors. Now there's two pieces to this. One is the foreclosure ability and the other one is the foreclosure incentives. The potential ability stems from the fact that the cable companies and the telephone companies are the two folks that control ubiquitous wireline infrastructure, right? Wireline infrastructure is important for wireless carriers. It's important today, and there are indications that it could become or maybe even will become increasingly important in the future. So, for example, I'm not an expert in technology, but what I gathered at the FCC is, as small cells become more important in the wireless space as a way to cope with the exploding traffic, you're going to backhaul, so taking the traffic from all these various sites and moving it back to some aggregation point, that's going to become an increasingly important input. Now, who has a dense wireline infrastructure? It's the cable companies and the phone companies. Now, you hear about other folks that provide backhaul. Those are folks that provide, high-capacity lines point to point, and but not in the middle of the cities. Not this dense mesh wireline infrastructure that the ILECs and the cable companies have. So, if backhaul becomes more important, the potential importance of cable companies as providers of this input grows. And in fact, there's a lot of evidence that the cable companies, even though historically they were not players in the backhaul space, in recent years they've become quite important. The second piece is Wi-Fi offload, and that's the idea that if you're a customer of Verizon Wireless and you get close to a Wi-Fi spot, if your phone could automatically default to the Wi-Fi, then you're economizing on the use of the licensed spectrum. And thought was that the cable companies are big providers of Wi-Fi. They developed it mainly so that their customers could watch video on the go. But those same Wi-Fi, that same Wi-Fi infrastructure could be used in the future to offer wireless carriers a wholesale product. Your wireless carriers pay us so that your customers can come in and offload traffic automatically on the Wi-Fi network. And so the thought was, so that's the ability part. If in the future, backhaul and Wi-Fi offload become very important, and realistically cable companies are one of the two main providers of that, if the cable companies wanted to raise prices or degrade the terms of service for those inputs to folks like Sprint, that could matter to Sprint, that could harm Sprint. So that's the foreclosure ability point. Now what about the incentive? Contractually it was clear that the agreements had no exclusivity provisions in backhaul or in Wi-Fi. No contractual exclusivity. But there is a potential incentive, and the incentive comes from the fact that the cable companies are selling only Verizon Wireless. They cannot deal with competing wireless providers. So if the cable companies raise an input cost to Sprint and a customer switches from Sprint to Verizon Wireless, some of those customers may buy Verizon Wireless service when they go to the cable company as opposed to buying it from Verizon Wireless itself. And that creates a profit incentive to the cable companies to foreclose Sprint's, folks like Sprint to T-Mobile. That effect was probably pretty small because you have to go through a chain of events. You have to divert a customer from T-Mobile to Verizon Wireless, but most of those folks will probably buy their mobile service from Verizon Wireless directly, as opposed to in the Comcast store as part of the cable product. So the incentives was, today, seem pretty small. The ability part was also speculative because it depends on how important cable will become in the future as a provider of backhaul and Wi-Fi. Potentially in the future, and this kind of sets up why the DOJ wanted to limit the duration of exclusivity both in marketing and in the job. By the way, the fix was that the DOJ said you have to end the exclusivity after 4 years, I think, same period, 2016 it was, unless the DOJ says it's okay. And similarly for the job. So they adopted the same idea. All of the stuff ends in 4 years unless in 2016, unless we say it's okay.
The only conditions?
As well as the conditions on the marketing of FiOS that I mentioned, the marketing of cable service, selling cable services that I mentioned. Now, last point here on the incentives. Why there might be stronger incentives down the road. Imagine that the Joe products really take off. Nobody quite knows what they are, actually. We kept pushing, what is it? Well, we don't know. If these things take off, you can imagine a situation where take a customer that is not currently a Comcast subscriber. Suppose Comcast, we're in the Comcast local market. But is a subscriber of either Sprint or T-Mobile or AT&T. If the cable company can raise the cost of one of these wireless providers and induce the customer to say, you know what, maybe I'll drop my Sprint service and instead choose this integrated Joe service that offers both mobility and fixed, this integrated service. Now that Sprint has raised its price, maybe I'll make this switch. For any customer that makes that switch and that wasn't previously a cable subscriber, in order to get a Joe service, you have to subscribe to both. You have to subscribe to Verizon Wireless and to the cable company. So that's a big diversion. There's no leakage at that point. Every such switcher, the cable company gets as a customer. Potentially, the margin that the cable company can earn as such a customer is much bigger than the margin that they could earn just by reselling Verizon Wireless service today. So the long and the short of it is that down the road, you can articulate scenarios that are certainly not a sure thing, but more than fanciful, where there may be foreclosure ability and incentives. So the remedy that the DOJ and the FCC agreed on, I think makes sense, is to say, look, we know there are, that's the last point, we know there are potential efficiencies, plausible efficiencies from allowing bundles, and from exclusivity, for the usual reasons that Josh Wright talked about. But we are worried about the extent and duration of this exclusivity, given that Verizon Wireless is extremely strong in the wireless space, and that the cable companies control such an important part of wireline infrastructure, or many. And so let's just allow the remedy on that was allow exclusivity, allow the Joe for a few years, but with the default being that it ends unless the DOJ says you can go ahead.
Okay, well, thank you, Marius, and I know there'll be some questions, but again, we'll table them for the moment. Final presenter in this panel is Babette, who apparently it is pronounced Boliek, according to the Reader's Guide. Clearly a Renaissance woman. We have Babette, who I've known for all of 25 minutes, is she's a professor at Pepperdine. She clerked for the Honorable Michael Mukasey. She has a PhD in economics. She has been a fellow at more than one fellow. You're quite a fellow.
That's what all the guys say.
Published in many law journals. Her talk is, I think, a little bit of a nice add-on to the two previous talks. Ellie talked very generally about broadband concentration and trends, sort of leaving hanging the issue of exactly what we should do about such a thing, if anything. Marius talks very specifically about a particular matter that got investigated in an antitrust framework. And Babette's going to talk more about regulatory efforts to deal with real or perceived problems in the area in the past, and look forward to her talk.
Thank you, Ken. Yeah, works great. Thank you. Well, thank you for everyone. Thank you for the great introduction. Ken and I were talking that it seems we're related because he taught economics to Tom Hazlett, who taught economics to me. So I think we're just.
I was in Tom's class. I don't want to.
There you go.
Tom's
we know what
economic expertise should not be taken.
Impugned or lack thereof. Is that what you're trying to say?
You were in my class. We were enrolled in the same class, but you were in class and I was somewhere else.
As I said, that's what I'm saying. Ken, talk economics, Tom. I know who I'm playing with. I've known Ken for 25 minutes, but I've known you for 25 years, so I know some things. No, it's great to be here. One of the places I was a fellow was here at George Mason, and it's with Tom and the Information Economy Project. It's great to be here. And great to be back. So I know that you've been here a long time, and you've been sitting through a lot of things. So and my time is a little shorter. And I have good news and bad news. The good news is I'm an economist, so I know what opportunity cost is, and I know that how to value time. The bad news is I'm a lawyer. So probably the time I'm saving as an economist, I'll spend as a lawyer. So we might end up right on the time limit. As Ken was saying in his introduction, my conversation with you today is going to be a little bit crossing over what we've already heard. It was good to hear Josh this morning speaking about what the FTC might do in the particular area of net neutrality, which has captured a lot of attention over probably the past decade now. And then we have Ellie talking about sort of broadband concentration. And I would say that a lot of the net neutrality conversation actually comes from concerns about concentration and concerns about what that can do to the competitive environment. So mine is going to be a little bit more specific along the lines of Marius, looking at what has been done in the past. What have we done for regulation? Sort of what arrows are in our regulatory quiver that we might be using? And in fact, public utility type regulation has been exactly the kind of regulation that's been bandied about as ways to deal with real or potential problems in the broadband space. Now, as Ellie pointed out, when we look at numbers, it's not to dictate which way our policy might go, but rather to inform the conscious decisions we're making. Obviously, we might calculate benefits in a different way that's more difficult to quantify, but I do want to put in a little bit of an empirical analysis to sort of discipline that conversation. And the other problem that Ellie pointed out is that when we're talking about broadband, there's a difficulty in that we often start talking about telecom companies because broadband is from a time series analysis issue, is actually a new arrival. So we don't have a lot of time series data on it. But I do think that we can, with some confidence, look at the way that telecom companies in the past have been regulated and try and get some information out of that to see how it has worked in the past. So that's what I'm looking at today. So again, this is spawned by general broadband access concerns, net neutrality being an example of that. And I'm going to use a very broad definition of this current sort of controversy or current policy decision, which is that net neutrality or broadband access that is ideal would have equal delivery and access to all internet content, applications, and consumer premise equipment. So very, very broad without getting into specifics. Now, the object of the regulatory focus and the policy concerns and the lobbyists has often been on this internet access provider, for example, the DSL, cable, Fios, and wireless. Now, the conversation basically is saying our goal is to maximize availability and innovation in this internet contact applications and network equipment markets. Some names that you might recognize, scholars in the field have been talking about this for some time in slightly different ways. Okay, so again, to just put this in perspective of what the modern case is, the call for regulator action comes from this idea of sort of a bottleneck in the market. And this is where it dovetails with concerns of concentration. And the bottleneck, the concern is that the bottleneck could provide some kind of hindrance to applications and consumers being able to access the major platform. In other words, that DSL and cable in particular are the platforms which applications need access to in order to reach end consumers. So there is general agreement, however, that to the extent that DSL and cable operators might want to do this, that they would be disciplined not to do this if there was competition in the market. We've seen these arguments before. And then it devolves into, well, what is competition? How much is competition? Okay. There's general agreement if we're going to go down this road, and I'm going to propose that this is actually not the most productive conversation, but many times we talk about maybe 4 competitors in the market. We see that number echoed all the time. In fact, it was slightly echoed by the Justice Department just recently in its concerns with ongoing mergers that might reduce numbers below 4. Okay, so the counter-argument is what we heard Commissioner Wright talking about this morning, that arguably many times regulation would prevent efficient vertical integration. Okay, you see up at first, Hazlett? There you go. So, knowing my audience, I would say that Hazlett has talked about this, obviously, and other people, but we don't, that's okay. Okay, so to put in perspective, if this is in any way new to you, I know it's not at all to some people, this is basically how the argument, at least in the policy sphere, has gone with an intentional lack of sophistication to show you that its applications or the edge are trying to get to DSL and cable, and of course the end user, that's also how they get access to the applications and edge. So the concern is that the middle, that the blue figures will somehow constrain applications so that end users are not able to. So basically. So here's the question that I want to look at, because the question of what to do with wireless in this argument has attracted some attention. And so I want to look specifically at wireless, because it does seem different somehow, and I think Ellie spoke eloquently about that, is how to define where wireless fits into this picture. As you saw before, in fact, usually the conversation was DSL and cable, and just that. And at the height of sort of the net neutrality before the regulations were actually promulgated, it was almost exclusively conversation with DSL and cable. If you look at the scholarly work, I literally did a word count of how many words were spent on wireless broadband access, and the percentage in the literature was extraordinarily low. So it was really something that wasn't hashed out in a very methodological way. So I wanted to take a look at this, whether or not there was empirical support for what I think is a more relevant question, which is not whether or not 4 competitors is sufficient competition, but whether regulation can do better. It's less what's the status of competition as if, given where we are, could regulation help us do better? Okay. So, again, looking at a couple questions, trying to see if is there market views for any competitive vertical restrictions as sort of a threshold issue. And then specifically want to look at identification of costs and benefits to consumers. Does economic theory, empirical evidence show whether or not regulation would help in wireless broadband or have some unintended consequences? Okay. So again, this is what the conversation has been, but the conversation, arguably, if we include wireless, might change the picture. So is this what we should be looking at? In other words, should wireless broadband just be included in the market? And as Ellie pointed out, it kind of has in the National Broadband Plan, but wasn't for purposes of sort of the net neutrality debate in the first instance, which is an interesting sort of set argument. But the other way to look at wireless might be like this, sort of a separate market. Right? And that's kind of the way that net neutrality went forward, is thinking about wireless sort of differently. But I would argue it could change the argument profoundly, depending which way we're going to look at it. Now, I just put in 4 circles as sort of a placeholder for the 4 well-known national wireless companies that are in there, although arguably there are more in certain areas. Okay. So that's kind of where we are. So here's the empirical analysis, is that I wanted to see if regulation is going to help consumers. The problem is we haven't had regulation of broadband. So I can't really say, did we have a non-regulation of broadband and a regulation of broadband and check. Couldn't do that because we just haven't had it. So I had to find, by analogy, something that seemed similar to the concerns. And I found it in the regulatory framework of wireless telephones. Now, wireless telephones, when they first started being licensed in the 80s, came out licensed to, for those familiar with it, obviously, it's 2 per MSA, or Metropolitan Statistical Area. And that was a federal decision. That's a federal licensing decision under the Act. And it was an interesting decision because they decided not to just license 1. They were relying on competition to bring this to market and help consumers. But they only chose 2 entrants. Another interesting regulatory move is they decided no price regulation. No price regulation either for consumers or for wholesale prices. The states, however, as my law students in the room will well know, can do what they want unless preempted by state authority. They can do intrastate regulation, and in fact, when it first came out, they did. There was extensive intrastate regulation, and the states did exactly what the states have done. They looked at this, they looked at telephones, they know how to regulate telephones, and they said, we know how to regulate telephones, so we're going to regulate mobile very much the same way. And they made a variety of choices, which is great if you're looking for data. Because then we get to compare. And we get to have sort of a comparison between all the different decisions. The ones that I focused on were looking, again, this is rate regulation, arguably slightly different than some of the stated goals for net neutrality. But the comparison is, I think, valid, especially to the extent that we also had not only consumer price regulation, but wholesale price regulation. Now, wholesale price regulation is aimed at getting more competition out there and getting more variety and more abilities for consumers to pick the levels of interconnection they want, etc. So the entire goal of wholesale regulation is very similar to a lot of the interconnection concerns that we have today. Okay. So the states also had final entry approval, terms and conditions they could do. Then a great thing happened for me. And that was because in 1993, we had a preemptive act, federal act, that basically preempted the states from imposing price controls and any kind of price regulation on wireless. So the nice thing about this is that we have a before and after. Also what happened at that time was that the FCC started increasing the number of licenses. So increasing the number of entrants into each market. So what that does for the data is I'm able to look at a before and after of the state regulation, as well as sort of a before and after of the entry that we see at the federal level, and to see which one had a greater impact on consumers. Now, it's very much part of the conversation that we're having today as the FCC is starting to open up more spectrum under the broadband plan. Okay. Again, here's the thing about prices that makes it very interesting in this market space. As almost a side note, this is what's called a two-sided demand system, because basically what we have traditionally done is that end users pay for access, and that the ISP does not charge the application except for its use as an end user. But as you can see, there's no reason why you couldn't change that pricing system or experiment with that pricing system and have some variance there. So that's, prices are very much involved in how you get access to the edge. Right now the default has been that you don't charge the application. Okay, so looking again at the regulatory regimes, and it's, as I said, it's very interesting across the states, the variety of choices that they made. And the good thing about that is I was able to delineate between all different types of regulation. So not just price caps or profit regulation, but just even terms and conditions or filing requirements, all the sorts of sort of bureaucratic paperwork things, and just try and sort of tease out what kind of impact they might have ultimately on the consumer. So looking at regulation high, I looked at both wholesale and consumer prices plus high wholesale, and regulation low included both this as well. Because some states only regulated wholesale prices and did not have any rate regulation on consumer prices. Okay, so you would think the whole point, obviously, the goal of the regulator in this case is to increase consumer welfare by keeping prices low. Right? That's the entire argument of it. So you're hoping that the higher the regulation, that the better the effect is for consumers. So, if that is true, if rate regulation was effective, what we should expect are negative signs. And as you can see, I didn't get negative signs. I didn't see that there was this correlation with high regulation and a high impact on signs. What I found was because of the level of statistical significance, that there was actually a positive but non-statistically significant effect. So at best we can say that this high level of rate regulation was not effective. Did not seem to lower prices as we would anticipate. The low regulation, ironically, actually was statistically significant. This is actually consistent with other people who have come into this with different data sets but similar time period. That even sort of what many people think, oh, there's no big deal kind of regulation, filing requirements, for example, could have an impact, and it could just be that it's the cost of the transaction. It's unclear. The other thing that was interesting was the wholesale prices to me, because that you would hope would be effective as well. But that seemed to not work very well. It's a very complex process to set wholesale prices as a regulator. And perhaps that showed well. Basically, it showed we can't find that it had any negative impact on the ultimate consumer prices. So again, a little bit disappointing given the amount of effort that the regulation took. So if we're asking the question just point blank, can we show that the regulation at least says what it's going to do? And in this case it's going to lower consumer prices. This data cannot show that. It can't show that it raised prices, but it can't show that it lowered them. All right. So I'm going to add to that. So those are basic results. There are a lot of other results, a lot of interesting results. The most significant and important thing was when we had entry. That had a very much stronger impact on prices, it lowered them, and so I was able to track that, and that was a very clear result. So that was very gratifying. So that's kind of what we would expect. You have more entry, you have more competition in the space, you would expect prices go down. On top of that, I obviously controlled for age of market and other things as technology develops. So it was a nice result to be able to see that, and so that seemed to be very effective. I just want to add to this as a last note. This is what we've seen, and maybe we can do better, but at least this kind of public utility regulation, this typical one that we've seen for how many decades now, was not effective in the case of wireless, and so it should at least give us a pause. And that's sort of the economist side of my hat. And then the other side of my hat, which is the lawyer side of me, I just got to throw that out too. And this might give us pause too, at least in this broadband space. When you do this sort of public utility regulation, it was under what's known as Title II in the Act. And that's a very sort of comprehensive type of regulation. But we're very unclear where broadband falls in the Telecommunications Act and where our jurisdiction lies, as Josh spoke about this morning. So that should give us pause as well, because we're not sure what extent we have jurisdiction as the regulator. It could be Title I and ancillary jurisdiction. That seems that's being retried basically right now. It could be Title II, especially if we renamed it, but there's many who don't think the agency should take that upon themselves, perhaps. But the irony of all this is when the decision was made not to include wireless in the net neutrality sort of policy. The irony is their clearest jurisdiction, the FCC's clearest jurisdiction, probably lies in wireless. And that is because they have a lot of power over the spectrum license agreements. They have used that power to introduce open internet policies in the 700 megahertz layer. And it does seem much more clear that they can do it there. But they decided not to do it for the reasons, technological reasons, and this conversation that we had about whether they even belong in this market space yet, whether they are true competitors with DSL or cable. So again, I would say this should give hesitation to whether or not we should add regulation, however, if we're going to be more extensive or introduce net neutrality principles overall for wireless. Again, just to echo what Commissioner Wright said, is that if you're looking at FTC jurisdiction, however, that is a much more straightforward jurisdiction than the Sherman Act, Clayton Act, FTC Act. Arguably, there might be some contentions whether the FCC solely can speak in the space. Trinker concerns for those of you who are interested. But I do think that they would be able to handle some of the competition problems that we're considering under net neutrality and other areas. So I'll let that go. Okay.
Thank you very much.
Okay, so I want to thank each of our speakers. I'll open up the floor to questions. I did first, however, at the risk of being accused of favoring producers over consumers, I wanted to give the producers an opportunity to ask questions of one another if they'd like. I mean, among other things, I was at least interested. Ellie presented a lot of information on concentration and trends. I'm curious whether people have views about things like performance and concentration. Maybe that'll come out in some questioning. For Marius, I'm particularly interested in why he feels strongly that the FTC is better suited to look at these things than the Justice Department. But I mean, unless one of them is chafing at the bit to ask a question of one another, I'd like to open it up to the audience.
If you'd like to come up here.
Oh, you mean oh, sure, the targets. I mean the presenters. I'm sorry. Okay. Oh. Concentrations being reduced in microphones. Okay.
I don't have it.
I see a hand. Okay. Question, yes.
Matt Warner.
Oh, speak loudly too.
Yes. Professor Noam, your data, did it include enterprise offerings? Enterprise with the residential, or is it just residential? Well, what was the data set? I guess I missed that.
It was by subscribers, and so in that sense, it was basically skewed to residential. The enterprise is probably figured as one subscriber. One subscriber.
But it would count as another ISP in the market, right? Sorry. So it did include enterprise. In that, would that count as another ISP in that market for the market?
No, it included ISP as a customer. I mean, the enterprise is a customer of an ISP in order to measure its size. Is that what you mean? Or you mean an enterprise being an ISP itself?
No, I just want to know if it included, if that was residential and enterprise as customers.
Okay, it was basically residential. There is a category of other, a few percentage points of others, and that presumably includes some of those, including, for example, the fact, as I mentioned, that I'm a subscriber, residential subscriber of Columbia University and the enterprise system, although kind of essentially run by Verizon for Columbia.
So is Columbia one subscriber? Is that sort of the question you're getting at?
Yeah, no, I think in this particular case, Columbia would be the ISP, and it would be included in other ISPs.
I think you only have residential as the U.S.
Yes, but I have Columbia as my residential provider. Frankly, I don't think, well, I'm perfectly happy to talk to you. I don't think it's terribly important.
Okay. Well, maybe during the break you pursue further. Yes.
John Mayo, Georgetown University. First, I enjoyed all the remarks by the panelists. But let me just ask one to my colleague, Marius Schwartz. Marius, when you were looking at the agreement, the spectrum code deal, you were really thinking about both efficiency and anti-competitive consequences. On the efficiency side, it sounded like the rationale was that consumers were moving toward driving bundles. And I guess my question is, was there a consideration of the sort of the geography of who the wireline provider was in this particular case? If there was and both on the efficiency side and on the anti-competitive side, I sort of start to think, if it really was a bundling thing, what was it that prevents Verizon Wireless from bundling with Verizon Telecom on that? And did you make anything of the fact that that didn't happen? And then on the anti-competitive side, did you read anything differently about anti-competitive consequences within the Verizon wireline footprint versus outside the Verizon wireline footprint? Because it strikes me again that those might be there might be some nuanced differences.
Yeah, so on the first point, it's well taken that there wasn't much bundling today. Part of that, in the case of Verizon, the story goes that they have a union issue, and Verizon Wireless is non-unionized, Verizon Telecom is, and if you go to a Verizon Wireless store and try to buy Fios, like there's the kiosk in the corner, and nobody quite approaches it. Eventually somebody will. I feel why we're not more enthusiastic. But that's something that they may work through, and reason to think that could change down the road. And the other point is, it hasn't happened yet, but it could happen in the future. As for the out of region, yes, I mean, that's why the concern with it was okay to say let Verizon Wireless market cable services out of regions and areas where Verizon Telecom doesn't have a footprint, right? But then the question was, in the Verizon Telecom footprint, potentially if they add Fios, that might dilute their incentives to, there's the potential to add Fios, and if you instead let them also sell cable services, I mean Verizon Wireless, it could dilute the incentive.
Right. I thought that was a very articulate case on the in-region issue. Yeah. The question was whether there's a difference in the thinking in terms of both the ability and the incentives to divert traffic out of region.
Well, that came on the wireless side, right? So if the cable, I should have said this, the cable companies that this deal involved control about, 70% of the cable lines nationwide. It's a big part of the country. So the thought was, if all these guys agreed to partner exclusively with Verizon Wireless, and each of them, hypothetically, were to raise the input cost to someone like Sprint or T-Mobile, collectively that could be a big effect. And I think that's part of it.
Yeah.
I have this question to Dr. Ali about
say your name,
my name is Sachin Garg. I'm a student at PhD student at SPP, School of Public Policy here. So this question was about the concept of concentration. So you looked at nationwide, and you say that nationwide the US has a pretty even spread. But locally, if you look at it, I think it would be there in South Africa. And everybody actually, either you can have cable from Cox or you can have Verizon Fios.
Well, South Africa was 10,000.
Yeah, I mean, it would be 5,000.
That's not 10,000, that's 5,000.
That's 5,000.
Okay, that's
so,
not South Africa.
Yeah, it would be something like that. I mean, we just have these two options. How is the policy going to change to basically give more choice to the end users, the consumer?
I think it may be like two questions. One is, if you look locally and really consider the choices available, are there only two in most places? That's one question. And another question is, what do you think about the future?
Right. What do you think?
Okay, well, first of all, two is better than one. And secondly, as I tried to show, it's just becoming more than two. Even forgetting about the satellites, it's at least the 3 and sometimes 4 out-of-region mobile companies are additional options. So the trend is in the less concentrated direction. That's number one. But I also tried to say, and that's kind of important, that while there is this concentration, lesser concentration on the broadband platform level, which is a good trend, as I expected, higher concentration on the upper level type stuff is going to lead to vertical integration issues, this time from the opposite direction, and therefore reduce the competition among the platform. Just to give you the intuition of what I mean is the kind of deal of AT&T and Apple a few years back with exclusivity. So what then happened was that in fact the competition among the cell phone companies was affected in AT&T's favor, because at that time it was the equipment, the handset, but you can also think that the exclusive access to the Apple apps gave an advantage, and that moving from an AT&T service, say, to a Verizon service, meant that you had to give up your app, so there was just kind of a much greater stickiness to their own providers. So that is an issue that seems related to net neutrality, but really from the opposite direction if you think about it. And so therefore, my advice to those people who have done these from the industry, these passionate net neutrality briefs is shred them, burn them, because they will come to Like you.
Actually, let me add one point to that, because that is something that in the net neutrality debate, people look at the broadband providers, and that's what the problem is. And the broadband providers say, well, what about Google? What about Microsoft? And the answer is, well, we're not here to talk about Google. Well, the truth is, bottlenecks, and I'm not taking sides here, but bottlenecks could arise anywhere in this space potentially. We've seen that in antitrust, but the Microsoft trial.
You can be big in one space, but
And
someone's
so Ellie's point is very well taken, that you really want to look at the whole space, not just say, okay, let's keep beating on the same old horses all the time.
I think we have time for just one more question. I apologize a little bit.
Coffee's important.
I'm sorry?
Coffee's important.
Coffee is important.
Here's the bottom between us and coffee. Bob Crandall again. I just want to ask one question of Boliek, and that is, wouldn't you look at the effect of pre-93 wireless regulation on network deployment investment? I mean, isn't that the real effect of wholesale regulation? Is that what we fear now? If there's wholesale regulations and net neutrality regulation, it would slow deployment of technology.
I looked a little bit about that. That actually was a little bit hard to find. Because the data that I have is MSA, so I wanted to pinpoint it to that. So I had some national numbers, but it doesn't dovetail terrifically. But I will say that after 1993, a very interesting thing happened in the MVNO space, which, as we learned from Marius, it's not the same as being an affiliate. It's for the lawyers or young lawyers out there, it's not the same as just being an agent. You actually do have some contractual control and independence. Once we had the wholesale regulation preempted federally, we had an explosion of MVNOs. It went from about 7 MVNOs to over 40 rather quickly. So that's a nice proxy for that too. I agree.
Okay, I want to, I encourage everyone to continue discussion with the panelists or with themselves. During the break, I want to thank them very much for the good presentations, keeping on time, answering questions well, and for your attention.
We've got another great panel for you now, and to moderate this, we have a friend of George Mason University, Gus Hurwitz. Has a degree in economics from George Mason University. Went on to the University of Chicago to get a law degree. He worked at the Justice Department. He's been here as a visiting scholar. Spent the last year at the University of Pennsylvania Law School, and is very excited to be heading to the University of Nebraska and to be doing telecommunications policy work there as a scholar, assistant professor, I think. Welcome to our world. And we wish you well there, but thanks very much for moderating the panel. Gus Hurwitz.
Okay, so I, much like Ken, believe in the role of the moderator as melting into the background. I do need to briefly say that I'm thrilled to be here. Dean Polsby was my first dean. He made a terrible mistake several years ago and took a risk on me as a visiting assistant professor here, and I have some former students. The first time I've been at a conference where I can say that. The Commissioner, Josh, was on my thesis committee, so this is a really cherished place for me. By way of brief introduction to this panel, we've been told in the technology world several times very curious things. We'll never need more than 640 kilobits of RAM. We'll never need more than 6 supercomputers in the world. Well, we're now kind of looking at the flip side question, where wise men historically have told us we'll never need more than we have. Well, in this space, we're saying we can never have enough bandwidth, enough broadband speed. And the panel that we're going to be looking at today is questioning that proposition, whether or not it's true or whether or not it's false. And we have 2 speakers here. We have Scott Wallsten, who is an economist with expertise in industrial organization and public policy. His research focuses on all the right things: telecommunications, industrial organization, regulation, competition, technology policy. He is currently the president for research and a senior fellow at the Technology Policy Institute and a senior fellow at the Georgetown Center for Business and Public Policy. Despite the order that things are listed on the program, he will speak second. We're going to go alphabetical by first name. Rob Kenny is going to be speaking first. Rob has an extensive background in this industry, having previously headed strategy or M&A work for a number of both domestic and international telecom companies. About 3 years ago, he helped to co-found Communications Chambers, and he has a particular focus on broadband issues and has advised parts of the Australian government and the UK Parliament. So with that, I'm going to hand off the mic and the PowerPoint to Rob.
Thank you very much, guys. Thank you very much indeed for the invitation to speak today. I appreciate that, and also to Scott letting me go first. I think we may actually be arguing in similar directions, which is unusual. I'm used to being in the kind of lunatic fringe on this one, so it's nice to find a fellow lunatic. You can judge who makes the case for lunacy better. So this area of super-fast broadband, as Gus said, there is a strong conventional wisdom that super-fast broadband is a good thing. Very simply, the case goes, some broadband good, more broadband surely better. And on that thesis, a lot of money is being spent around the world, much of it by private companies, which is fair enough, that's their lookout. But also a lot of money is being spent by governments. There's significant government intervention in favour of super-fast broadband around the world. Extreme cases are places like Australia, which we can perhaps talk more about later. Australia is spending $43 billion of taxpayers' money on super-fast broadband, which on a sort of per capita basis is the equivalent of the US government spending $650 billion, which is real money. And while other people haven't quite spent that amount of money, they are making significant changes to the landscape of telecoms regulation and policy in pursuit of super-fast broadband. So if it isn't cash, it's often regulatory holidays, for instance. So in Europe, where we have quite heavy wholesale regulation on incumbents, requiring them to make their network open to third parties, they are being told if they invest in superfast, they will be let off those regulations for the superfast portion of the network. Spain, Portugal being examples. And also, there's renationalization going on. Now, of course, in the US, the telecoms infrastructure has always been in private hands, but that's not the case elsewhere. With heavy government ownership, we went through a couple of decades, roughly from the mid-80s through to the late 90s, getting telcos out of government hands, privatizing. That painful and bloody process is now in part being reversed in pursuit of super-fast broadband. So Australia not only is bringing all that money to work, but is effectively nationalising its access network. And to a lesser extent, that's happening elsewhere, places like New Zealand and Singapore. So, what I'm going to argue today is that that set of changes, that investment is, to use a technical term, bonkers. Right? It is incredibly, incredibly poorly founded on the supporting data. So, let me just start with some of the claims being made in favour of superfast broadband. And I think it is fair to say that its advocates are being somewhat generous with what superfast will bring you. And I've been careful here, right? I haven't chosen sort of lunatic, tech junkie, tinfoil hat brigade people. I've chosen extremely blue chip organizations. So here's Cisco. They put out a paper last year that, amongst other things, said video, audio, and maps will all need fiber to work. Now that's probably a bit of a surprise to those of you who have ever used Google Maps on your cell phone, right? It just simply isn't true, right? But so strong is the conventional wisdom that fiber is great that such statements get a free pass, right? And so one thing I'm trying to do today is to equip you all with a healthy cynicism. I urge you to read documents in favour of superfast broadband with your common sense engaged and switched on, and we'll come on to it, but for God's sake, check the footnotes as well. UK Department of Business. So when they published the UK's broadband policy, they cited a particular Australian trial that they said was an quote-unquote an excellent illustrative example of the benefits of superfast broadband. Now they didn't say this, but if you look to the footnotes, you went back to the sources, that trial used 64 kilobits per second. Now it might have been an excuse to move beyond dial-up, right? But it certainly was not an excuse to invest in superfast. OECD, another very sensible most of the time, organisation. They put out a very widely cited report a couple of years ago that talks about what one of the things Superfast was going to be for electricity, transport, a few other areas. So it's a big potential savings. And they said, fibre will enable smart meters. So those are those meters that sit in your home, monitor your electricity usage, report it back to the power company. And there are no questions. Smart meters are a good thing. I'm not arguing against smart meters, right? They're great for CO2, all sorts of things. But they don't need fibre. They can use fibre, but they don't need fibre. And the most practical example is the Telextor program in Italy has 30 million smart meters installed today. It uses primarily the GSM network and the existing copper. One of the reasons the OECD got confused on this, other than just kind of wishful thinking, was that they muddled one of their sources, which had the bandwidth required for a small town, with the bandwidth required for a single household. Right? And it's because basic common sense is not being applied here. Now, I've left my favourite to last. The FTTH Council, which is a lobbying group in Europe in favour of fibre. They have a video, it's up there. The footnotes, by the way, will be with the slide, that says one of the uses for fibre to the home is remote surgery. So I have this image of somebody with a webcam pointed at their stomach, taking out their own appendix with a spoon under the direction of a remote surgeon. Right? It doesn't stand up to common sense. So, one of the reasons why governments are having to think about investment in this case, in superfast broadband, is because consumers, I generalise slightly, but consumers have blown superfast broadband a resounding raspberry. Right? If consumers were excited about this stuff today, or willing to pay for it, we wouldn't be having this conversation about government intervention, right? The market would have sorted it out. But that's not what's happening. And in market after market, the willingness to pay any premium beyond a small group of enthusiasts, willingness to pay any price premium for superfast just isn't there. When you look at places that have high penetration, Japan, South Korea, Hong Kong, not only do they have sort of physical and demographic issues that mean it's much cheaper than to roll it out, but to get it into the hands of consumers, persuade consumers actually to buy the damn stuff, they've had to price it at near as damn it, or indeed cheaper than, existing DSL-based broadband. If you look at the charts with bandwidth across the bottom, price up the left-hand side, and you plot all the price plans, it's a bit of a cloud, but it is a horizontal cloud. It is not a line that goes up and to the right. And there's numerous people saying that, Ofcom, the UK regulator, JP Morgan, and then two very respected telecoms analyst firms, all saying essentially the same thing. Consumers won't pay any premium for this. Now, even the penetration that there is isn't often the result of what I'm loosely calling forced upgrades. Now, it's not an objectionable upgrade to be told you're going from whatever 15 to 30 megabits per second, so that's why I put forced in quotation marks. But it is a decision that was not made by the consumer, it was a decision that was made by the ISP on their behalf. So, for instance, a lot of the penetration of superfast in the UK is to do with Virgin Media, our cable operator. And Virgin Media just doubled the bandwidth of all its consumers over a period of a few months, right? Good thing, I'm not complaining, nice thing to do. But what you can't do is use that data to say, oh look, consumers love superfast broadband, because they didn't choose to have it. So we've got a bit of a problem with consumers being unenthusiastic. Now, one of the arguments is, well, okay, consumers are unenthusiastic, but it's early days yet, right? We'll build this, and the applications will come in time. Now that's not an inherently stupid argument, right? But the problem is we have already built it and they have not come, right? The penetration of fibre today around the world, end of last year, at 107 million lines, most of which are in East Asia. Again, Japan, Korea, South Korea and Hong Kong. And even that definition excludes a lot of fibre to the cabinet lines, which can be pretty damn fast, and cable lines, which also can be pretty damn fast. So what's the significance of that 100 million penetration of fibre? It is about the same, slightly more than, the penetration of basic broadband in 2003. Where have we got to in terms of applications basic broadband in 2003. We had iTunes, we had Skype, we had streaming video, we had movie downloads, we had a lot of stuff. Indeed, we had most of the things that broadband is used for today, a decade later. Now, they were early stage, I'm not saying on mass market, but they were there. You could point to them, right? And you could say, gosh, when broadband is widespread, we're going to be able to use these things. That's great. It's one of the reasons people got broadband. But if you ask the equivalent question about superfast, which has the same 100 million critical mass of people who could be using the applications, you get a resounding silence. When you say to people, what are the applications that are going to drive all this? People can't point to them. And that's not just me as a cynic saying that. There's our friends, the FTTH Council, who believe in home surgery. They say there are no really compelling applications yet for fibre. So this is, even by the enthusiasts, there's an acceptance that we just don't have the applications yet. And I think maybe 5 years ago, it would have been okay to say, but that's all right, they'll come. After 100 million households, it feels like they're overdue. And it's one of the things, when people say, you know, gosh, it's terrible, we're falling behind Korea on superfast broadband. The question we ask when people say that is, okay, well, you know, so they've got a lot of fibre in the ground, and they are ahead of us in that. What are the applications that they have in Korea that you're envious of? What are people doing with that broadband in Korea you wish you could do here? And they get a bit squirrely at that point. Start looking around. And I mean, I've asked this, for instance, I've asked that question to the head of BD UK, Broadband Development UK. He's the guy who's got responsibility for sort of pushing along superfast broadband in the UK. Doesn't have an answer to that question. So, fibre is only glass in the ground to other applications, and the applications aren't there and don't appear to be coming. So, there may not be a killer app, but there's another potential argument that's made for superfast, and that is concurrent use. And this argument goes, and again it has a degree of legitimacy, so it's not about one single application. This is about households doing a bunch of stuff simultaneously and their aggregate bandwidth needs. Okay, good so far. Now it's the right way to look at the household as a unit, because it's the household that uses the cable connection or fibre connection, whatever. So, here's NBN Co. In Australia. NBN Co. is the government entity that has been set up to spend that $43 billion. Quick aside, NBN Co. is great. NBN Co. means that no matter how stupid your broadband policy is, there's somebody with worse broadband policy. Here's NBN Co. and why they say, oh, we'll get to 100 megabits pretty damn soon. Significance of 100 megabits being, at the moment, that is a level that requires you to build fibre to the home, not just to the cabinet. If you want to deliver that much speed, you've got to do the expensive work of digging outside it. So here's what they say, tots up to 100, actually, it's even a little over 100. There's that set of applications there. So I'm going to bore you by reading them all out. You can see them on the slide, but let me do. So advanced internet, 20 megabits per second. That's a lot for advanced internet. Gaming, 2 megabits per second. 2 standard definition TVs, 2 HD TVs, hosted applications, telephony, peer-to-peer, 3D HD TV, video calling, at least a couple of smartphones, 24 megabits per second. There's a hell of a lot of use on a smartphone, and video conferencing.
How many people?
That adds up to at least 8 people. At least 8 people, with them doing some pretty damn impressive multitasking. Right? 8 people. Even teenagers are only equipped with 2 pairs of eyes and 2 hands. 8 people. The average Australian household size is 2.5 people. And actually, the number, give or take, that's actually quite a common number in the West. 2.4 through 2.7. But that's the typical number to have in mind about household size, about 2.5. And the other thing to have in mind is that 2/3 of households in most Western societies have 1 person or 2 people in them. Now, what gets talked about time and time again in this debate is, imagine the household with the mum and the dad and the 2 teenage kids. That is not a false example, but it is absolutely not a representative example. Right? That is not what most households look like. Most households look like 1 or 2 people. And there's another enormous, and to my mind fatal problem with using this scenario to justify government intervention. Anybody want to take a guess at the economic status of this household? Okay? This is not somebody at the margins of society, right? Yeah. Clearly unemployed. No, we can't even say that. Look, they're working from home. They're on the income. No. This is clearly a very, very prosperous household. And the idea that the general taxpayer should have money taken off them to subsidise this household, personally I think is not just misguided but wicked. Okay? This is a highly, highly regressive government intervention. So, final slide. Ultrafast, a huge investment to make on the basis of hope, right? This is a big, expensive government intervention. And I think, therefore, for that reason alone, should pass quite a high burden of proof. And you cannot simply extrapolate from the wonderful benefits of broadband, right? And I am not an internet Luddite. I am an internet wild enthusiast. But because broadband already has delivered us so much. But you cannot simply extrapolate, right? If you could extrapolate, then Concorde would have been the best thing ever, right? 747 was good, so, you know, faster, surely better. Well, you know, Concorde didn't work out quite so well. It turned out there just wasn't demand for speed at that cost. As I've said, applications for superfast are, I think, now appreciably overdue. That doesn't mean they won't come, but it is an argument for increasing caution and scepticism. Application stacks, that, as we saw on the previous slide, to justify superfast, ultrafast, are, I think, literally incredible. You cannot believe them. So, government intervention for superfast, highly regressive. Likely beneficiaries are people who are doing extremely well already. And it's not as if there aren't other good interventions available, right? And governments are also, to some extent, intervening on these lines as well. I think much better places to intervene are not spots, places where basic broadband is poor. Right? And there are all sorts of technical reasons why that happens. There's a portion of people who really struggle on DSL to get even a few megabits today. I think that is a legitimate area for intervention, but also uptake to get everybody online. So again, it varies, but in the developed world, we're sort of in the 70-80 percentage points penetration for broadband. And if we're going to make a choice of intervention, is the right answer to give those people already online, perhaps enjoying 5-10 megabits per second, spend a lot of money to get them up to 100 megabits per second for applications that no one can identify yet? Or should we be focusing on that last 20% and getting from currently 0 megabits per second to 5 megabits per second? The step up from not being online at all to being online on basic broadband is massive. It's massive for the individual concerned. Plenty of research to show they end up paying lower prices for things because they can crash and shop and so on. But it's massive for society. Those people can start doing online taxes and so on. I mean, all sorts of externalities for society. And ubiquity also has its own value. If you can get to a point where, for instance, it is a safe assumption that all the kids in your school classroom have internet access, then homework suddenly becomes very different. But as long as that's not the case, it's all going to be paper and pencil. So I think there's a huge legitimate argument for internet intervention and getting that last 20% online. I think it is a far better thing to be spending money on than ultrafast. And that's what I say.
Okay, thank you very much, Rob. I don't think that you really understand the norms here. We actually have 2 minutes left from you, but rather than you hold on to them as a monopolist, I'm going to take them back and just hand the mic right over to Scott.
It's called use or lose, right?
Right. Yeah. I don't have anything. Oh, here it is. Okay, so basically what he said. Right, that's right. But I'll say it with an American accent, and I have more pictures. So, and I know that Tom and Brendan and IEP really tried to get somebody who would give a different point of view. So it's not their fault that we're the same. So I would encourage people to argue, and we'll tell you exactly why you're wrong. Okay, so let's go back to the claim. I'll focus also more on the United States. So there's a claim that US broadband is too slow. And so there could be two possible underlying assumptions or implications from this. And the first is that, well, maybe speeds are too slow for existing applications, or maybe that speeds are too slow for upcoming applications. And then as a sort of a sub part of that, that speed is a barrier to innovation, right? And especially looking forward, you might worry about its effects on innovation. So first, are speeds too slow for current applications? Well, this is from, these are speeds measured by Akamai. Akamai usually measures kind of low compared to other measures. But we have the average speed in the US being 7.2 megabits per second. This is measured, not advertised. And it's up 20% from last year. And just to give you some perspective, in Japan that measured was 10.5, not the 100 you hear about all the time. And France was just about 5. I don't actually know why Akamai consistently measures France to be so low. They're usually higher than that. But those are kind of the speeds around. And then they also
include enterprise or just residential?
But it only has one measure for Columbia. We don't actually.
I think it's alone.
It's both. Yeah, most of them include both, but they don't tell you. And then they've also tried to do this. They do this peak speed measurement thing too to try to get what they say is a more representative number. And that has peak speeds in the U.S. measured at 30. Up a lot again by comparison what they measure, Japan 42, France 19. Okay, so are these too slow for today? Well, we already saw that basically they're not, right? What are the things that people do today? Netflix, Pandora, Skype. Netflix, if you want to watch HD Netflix, that's less than 5 megabits per second. Pandora, you can do that on a 2G wireless network. It's 128 kilobits per second. Skype, if you want to talk to 7 or more people at once, you can get up to 8. On a video chat, but that's about it. So we're pretty good for today's applications, right? Our speed's a little bit too slow for today. No, that's pretty clear. And this is, as we already heard, there's very little demand for fast speeds today. So let me just add one more site to that. A paper by Greg Ross and Scott Savage and Don Waldman in 2010 looked at demand from willingness to pay for different attributes of broadband. And people like their broadband a lot, and they were willing to pay quite a lot for reliability, and for speed up to some point. But to go from what they called fast to very fast, people were basically willing to pay nothing for that extra increment, which is completely consistent with what you heard before. Now, but our speed's too slow for tomorrow. So just to take a quote from about a week ago in GigOhm, you don't need a gig today, but you need one for tomorrow. Well, I don't know, do you? I don't know. Maybe. Maybe yes, maybe no, maybe yes, maybe no. Really have no idea.
I'll pick with economists, right?
That's right. Yeah, this space station also it's okay. But let's just say that you will need a gig tomorrow. Let's be generous with tomorrow. Oops, that's it. I'm done. Conclusion. I know. Well, if I don't keep going at this speed, you'll never get out of here before dinner. All right. So even if you will, it's a problem only if supply doesn't continue to evolve with demand. And when people talk about, they'll say, okay, look, this is what we're going to need for tomorrow. Look at how demand is increasing. And then they act as if supply isn't going to change at all. And so you've got to consider both of these, right? And so let's look at what's happened over time with these measured US speeds. Now this one is from speedtest.net. Speedtest tends to measure higher than Akamai. But you can see since 2008, their measured speed has doubled. And probably this big jump at the end is more DOCSIS 3 kicking in, is my guess. I don't really know. And so we see that speed has been increasing pretty steadily over time, right? Now, so the policy question for speed is a policy issue. Do the expected benefits of increasing the rate of increases in speed exceed the costs? Right? Nobody asks the question that way. They just say, we need more speed. And that's the question. I don't know exactly how to answer that question, but that's what we should be asking in a policy sense. Now, we also focus on speed, solely on speed, as if that's all that matters, right? What if other quality attributes matter? And instead, all we do is focus on speed because that's the only thing anybody understands, right? You can put that on this many megabits per second, and people understand speed, faster, slower. But broadband has a lot of quality attributes. So, and that our obsession with speed might have costs. So there are lots of types of quality. One is speed. Another is latency. I couldn't think of a good slide for latency. It's how fast it's round trip. So I had a little gif of Pong with the thing going back and forth. Jitter, how that's a variance in latency. Yeah. These GIFs do get annoying after a while. Packet loss, reliability, a whole lot of other things. Now, we know that speed isn't always the most important factor. So if you're a gamer, for example, another very important social good, gaming, you don't really care so much about speed, you care about the latency. When you push the button on your controller, you want your character to do something. You don't want to have to wait a while. And so these various services, they point out that this is the most important aspect for that part of use. And okay, so there are other things we care about. Now this is a table from an Alcatel-Lucent report on smart grid. What different types of quality do you need to make smart grid work? And they didn't actually define too precisely what they mean by high, low, very low. I found some examples in the report. But like for example, this with pellet production, this rapid security stuff. You might need a fair amount of bandwidth, and that seems to me maybe 5 to 10 megabits per second. But you need very, very low latency. You want it to happen in very real time. Other things don't need as much latency and might not need very fast speed, very much speed either. And you have reliability and security. So there are all these things that matter in addition to speed. Now, sort of another example, different consumer types value different attributes. The businesses tend to value reliability over speed, of course depending on what the business is, right? But mostly they value reliability over speed. Now, a nice example of this, over the last week or so, we've been hearing about not a 1 gigabit per second plan, but a 2 gigabit per second plan that's being offered in Japan now by this company Sotel that was bought by Sony. The reports have been putting Google Fiber to shame, and it's about $50 a month. Why can't we have this? And of course, all the reporting seems to be done on Twitter, as far as I can tell. Nobody's bothered to even look at their website to see what this is all about. And so you dig down a little bit, and if you want this for a business, businesses are always more expensive to buy. It's always they always charge businesses more. They want more reliability, better customer service, and so on. But so with this 2 gigabit per second plan, if you want a guaranteed 30 megabits per second, it's going to cost you an extra $500 a month. Business plans are costly. But so, they want reliability. It's clear that, it's not really the 2 gigabits that people are buying there, right? That's also 2 gigabits, it's just a GPON system. It's 2 gigabits to whatever the building is, and then everyone has to share it. That's why they can't guarantee anything close to that speed. But also now, technology, demand, everything affects the direction of innovation, and that changes the relevant quality attributes. So now, we've gone more and more wireless. And the question isn't, does wireless become as good in certain ways as wireline, but how does everyone using wireless affect how we're innovating? We're focusing more on apps now, wireless applications. And that completely changes the direction of R&D, direction of innovation, and how much speed will matter in the future relative to other things. And it could change again, of course. Right? Now, the problem is that what gets, this cliche, right? What gets measured gets done. And we know that these speeds are increasing, partly just in response to demand, because that's getting up to 5 megabits per second, 10 megabits per second. That's pretty beneficial, right? That's helpful. And once you go beyond that, still, as we heard, not so clear. Okay, what gets measured gets done. But now, speed tests, and another slide I'll show you, have started measuring these other factors, latency, jitter, packet loss, and those have been increasing, not packet loss. Now, is this just an anomaly because they're still getting these measurements right? I don't know. Are these at levels that affect anybody? I don't know. But while we're focusing on speed, other stuff's happening, right? And we're not paying any attention to it. And is this just an anomaly? Well, the FCC has been measuring, with the Sam Knows project, and everyone focuses on the speeds, advertised versus measured. Even though we know that pretty much everyone gets what's advertised here. If you look at the highest tiers, these measures of latency have been increasing. Now, still, those are pretty darn good numbers in the 20 milliseconds. That's not bad, right? But that trend doesn't look so good. Now, these are very brief periods in time, but still, remember, what gets measured gets done. We're focusing on speed. Speed's going up. Speed doesn't seem to matter. Other stuff might matter. We're not paying attention to other stuff. Other stuff might be getting worse. Now, having said all that, you can imagine what I think about Google Fiber and GigU and so on. Well, actually, I think they're great. And you might find that a little surprising. But, right, yeah, you might find that surprising. And the reason is because, first of all, it's competition, right? It's a private company. They're building out networks, and we like competition. And competition is good. It also has revealed how much local rules and regulations inhibit all kinds of entry. Right? Google had this national competition to find out, to pick the best place based on lots of factors, but among them was who would make it easiest for them to roll out. And I think this is very illustrative. And it's also, it's an issue that even affects some incumbents, as we heard that the cable companies are trying to build out Wi-Fi networks. Well, they discover that it's hard to get access to utility poles in places. These are local rules really make build out difficult. And that affects entry. Second, maybe I'm wrong, right? What if speed really is the important margin? So it's nice to have people sort of trying experiments, especially when it's their own money. And the third is that they're actually, we want to focus on kind of the low end of the spectrum because that's where there is a real digital divide, people who still haven't come online. And price is going to be a big part of that. And they have some interesting, there's some innovation there on the low end, which we haven't heard too much about, or they haven't emphasized a lot, and it hasn't been too much part of the news. Although the US actually does pretty well on affordability rankings. But, so they have, the gigabit side, that's okay. The prices are pretty good, those are good prices. But this free internet down at the low end, if you pay the connection fee, that's an extremely low price for a 5 megabit per second service, which is pretty much good enough to let you do pretty much anything right now, except maybe that crazy family in Australia that's doing those 47 activities all at once. And so this is really interesting. And could that kind of thing make a difference in the digital divide? Well, we don't know yet. Also, there's a question of whether it's a sustainable business model, and that's not clear at all. But still, that's kind of interesting. So, just the conclusions, that basically for now, speeds are fine, and they're increasing steadily. We don't know what will matter most in the future, so don't prejudge. It's insane for us to assume that speed will be the most important thing, and we must reach some arbitrary target that somebody picks. And for policy purposes, we should be asking what quality attributes and other external factors pose barriers to innovation in which areas, and those are what we should be looking at. So that's it.
Stay up here. Right. Do we have a second microphone?
Okay, so we have yet another speaker who didn't use all of his time, which in a sense is good since we were running a couple of minutes late. We have time for several questions. I think we'll just keep asking questions until Brent waves at me angrily and says, no more. And I see some hands right now, so I'm not going to exercise a moderator's prerogative here.
They finished early, so there's an early termination fee.
Is there anyone from the FCC who will oppose the early termination fee?
Yes.
Yeah, I'm Sachin, I'm SPP of the PhD program. My question has to do with this. It was a very interesting point you brought out about the fact that latency is an important factor that has never been considered. And as a person who has actually worked in one of the companies, I know it really used to impact our business model, and we really worried a lot about it. And your point about latency in the US being 25 milliseconds has a lot to do with the fact that there are a ton of data centers in the US which are very well connected. But as I have learned, that's not the same case everywhere. Australia, for example, is all to learn. I mean, because the company I was working with really found it very difficult to get to Australia, and a lot of other, London also, I don't think in UK has a lot of data centers. So, interesting, the policy debate could also shift to as to what are the ways to make better internet access, like IPv6, what is the policy around the V6 deployment, what's the policy about reducing latency, what is the policy about allowing more competition in the data center market rather than just being fixated on the big bang size of pipe, which honestly speaking, after a particular level doesn't really matter. What's your thoughts on that?
I think it's a great point. Yeah, there are lots of factors that matter, and why we sort of have obsessively focused on just one as a policy matter is sort of bizarre.
So Scott, are you suggesting that the companies are not responding in the way they should in the market to the non-speed quality factor?
Are you Tom Leonard from the technology policy?
Well, I don't know. Will I get a raise this year? No, it's a good question, and I don't know exactly what those measures mean yet, because the reports haven't focused on them and haven't done a good job. Haven't really explained them, and maybe those are also not a barrier, and so they're increasing because there's not consumers. I mean, it doesn't affect consumers. It's not at a level that would affect consumers. So I don't know, and I think it's an excellent question. I mean, it could be the case that, let's say that those factors are getting worse, and it's because they've had, one possibility is that they have to emphasize areas where the regulator is watching, and that takes resources away from other areas. That's one possibility, but there's certainly other possibilities too, and I don't know the answer.
And I'll supplement that, and I think it's really, really worth having in mind what the consumer purchase decision looks like for broadband. It's horrible. It is horrible, right? When you are trying to assess broadband providers, we talk about speed, and people in this room probably have a pretty good idea what a megabit per second is, at least conceptually. And I can tell you a lot of people don't. I mean, one of the reasons we know that is when the consumer research is done, now, how much speed would you need to be able to work at home? A gigabit per second. I honestly don't think you do. Right?
Might say gigabyte per second.
Gigabyte per second. Consumers don't even understand this metric of megabits per second. I generalise, obviously, but a significant part of the market doesn't even understand the one metric we're offering. Before you even get into the difference between up to X megabits per second and what speed do they achieve and so on, the purchases is also bundled together with a whole other set of stuff. So you're thinking about, oh, well, actually, but if I go to this broadband supplier, do I still get to watch my favourite sport team? And I mean, it's a really messy, horrible decision where even if the information is presented, the consumer is not necessarily well equipped to kind of process that and come up with the right answer for them. Right? So by the time, once you move away from the headline numbers, saying things like latency, I think the ability for market discipline to kind of nudge companies in the right way, it's not that it's not there at all, but I think it's weak.
Yeah, actually, that's a good point. And to follow up on that, in the paper that I mentioned, evaluating willingness to pay for broadband, that was a paper I commissioned when I was at the FCC. One of the difficulties was in getting people to, in having people value speed. People don't know what speed is, and so you have to do, say slow, fast, very fast, and then sort of define what you can do with each of these categories, and then you try to work it back with what those mean in terms of megabits per second. But yeah, people understand. I think at one point Comcast tried some marketing using describing speeds in terms of what you could do with it, and I think they may have stopped doing it that way. I'm not sure, but I think it is a problem the companies face too in trying to explain to consumers what different speeds mean.
Ellen.
First, I thought these were two really great presentations, and I've sometimes argued in the same way, so I also know where the weak parts of the arguments are. So, first of all, you talk a lot about fiber, but the fact is that there is already a super fiber around. It's called cable television, HFC type stuff. It gives you the potential for gigabits and passes 90% of possible. And some of the investments that you heard about are essentially in response to having that kind of very powerful fiber that can be upgraded as demand grows, but it is already in the ground. And somehow its economics seem to be working just fine. So in the demand for it is just fine. So what's kind of what gives here? Now, second point. When you look historically, people have always set their sights very low. Do you need more than 3 TV channels? I wouldn't know what to do with a pause of 50. And do you need HD TV? Not really. It took 30 years for color television to supplant black and white television. So people generally kind of don't actually know what they want, but when they have it, they will never go back. And so here, say take television quality. what we have is that people are used to these 525 lines and maybe 1,000 lines now or whatever. But when you sit here in front of a TV screen that is the size of this screen here, and you sit at it reasonably, and that's where the TV screens are going. Clearly, what's happening in Las Vegas and so on. But houses, apartments don't grow in size. So you sit in front of a much larger television. The graininess increases, so you have to move to 4K, 8K. In Las Vegas, already 11 manufacturers showed 4K televisions. And probably in 2 years they'll do the same for 8K. But if you add 3-dimensional 3D, and you add a better pixel resolution from 3 to 4K, if you add some kind of immersiveness and broadening and so on, you get very rapidly, even with compression, to a gigabit range. So my prediction is, sorry about this, but in a few years we will be sitting here debating, is terribly necessary?
So I'm so glad you asked. You brought up this point because I was hoping somebody would say something. First of all, on the size of the pipe of the cable pipeline. Remember, that's broadcast. They're sending every channel to everybody. So if we want to broadcast the entire internet to everybody 24/7, yeah, we're going to need some big pipes. And so that's, I don't think that's, now second, what we will need in the future. Now, also I remember, I think it was 3 years ago at one of the Columbia State of the Net events, you said something very similar. You said in a few years, we're going to need, well, it's a few years later now, still don't need it. I was also at the NAB show, and there were a lot of companies doing 4K TVs. Do you know what 4K TV needs to broadcast, to stream? 20 to 25 megabits per second. That's without any compression and innovation. Now, first of all, I don't want anything that happens in Las Vegas to be, no, it is true. But look, there'll be more innovation in this. Yes, there'll be more innovation in both sides of this. But also, what was on display 4 years ago at CES? 3D TV, right? Where did that go? The point is, we have no idea. The point is, Ellie, we don't know where technology will go. And as long as the supply can continue to evolve with demand, yeah, we might see huge spurts in needed bandwidth. And I totally agree, that's a possibility. And I'm not saying that we will never need, this isn't one of those points saying, we'll never need more than 64 kilobits of RAM or like that. I don't know where it's going to go. And we should be open to innovation